May I make a mention, my lord?
Sir, list 253 number, serial number. Urgency, your lordship has to please help us.
No.
Challenging the immunity rejection order under 270 AA, my lords, and the respondent is proposing to file the immunity order. Kindly be listed for tomorrow, my lords. Fresh matters.
You have to move it usually on tax. Tomorrow will be some other roster.
Only this matter.
It was correct. You could have moved it yesterday, isn't it? You would have
But,
come
sir,
today.
it was not there. Much.
If the other side is not there, then automatically you'll get that.
I will inform and serve copies in advance.
Correct. For them, there is a difficulty. So they have benches on subway. Anyhow, give it. We'll have it.
Yes, much.
What we have mentioned. We have mentioned item 27 in today's list. Also, some
Page wise.
adjournments. List one,
Give it to
page number 1, 1 to 5, page number 2, 6 to 10, page number 3, 11 to 17.
request. You have informed the other side. You have informed the this date. This is 15, is it? 16. Yes. Yes. The directive is extended to the next date.
Page number 4, 8, 20, page number 5, 21 to 23, page number 6, 24 to 27, page number 7, 28, page number 8, 29 to 33, 52, page number 1, 1 to 5, page number 2, page number 6 to 12, page number 3, 13 to 18, page number 4, 19 to 26, page number 5, 27 to 34, serial number 31, 34,
Same stage.
18. Page number 6, 35 to 41, page number 7, 42 to 47, page number 8, 48 to 52, page number 9, 50 to 56, page number 10, 57 to 61, page number 11, 62 to 65, page number 12, 66 to 70, page number 13, 69 to 73.
Serial number 73, my lords, I appear for the petitioner. I've informed the Mr. Madan Pillai as well as Arvind Chauhan. For respondent number 1, my lords, the name of AJ is to be shown. That is what Mr. Chauhan has told on the last date. And a date may be fixed after showing the name of AJ for respondent number 1, my lords.
I am appearing. 73, I am appearing.
If he's appearing, my lord, this matter is a covered matter. It may be taken up at your lordship's convenience, my lord. Even the division bench has upheld the single judge's order.
Division bench judgment.
Covered.
Regard to affiliation charges, no, that's
Covered.
In fact, only 2 days back, the division bench has affirmed the order passed by the learned single judge.
List the matter. On top of preliminary hearing list on 17th of
Grateful.
name of AGA for instead of for R1 and R2.
Only R1, my lords. Only
for
R1.
R1 instead of the name of Arvind V. Chauhan shown. Yes.
Page number 14.
In interim order may kindly be extended, my lords.
Interim orders in operation are extended till the next date.
Grateful.
Page number 14, 74 to 75. Page number 15, 76 to 81. Page number 16, 82 to 83. Page number 17, 84 and 85. Page number 18, 86 to 89. Page number 19, 90. List 3. Serial number 1. My lords.
Tomorrow, special court matter.
Just wait. 3B group. Yeah, with the connected matter. Is batch matter. List 3. Yes, income tax.
Yes,
This is ready, is it? What is this list?
Your Lordship, regarding reassessment proceedings initiated by the assessing authority, my Lord. The question whether the conditions are satisfied or not.
But why is it grouped?
Your Lordship, issues one assessee, my Lord. Therefore, it has been clubbed.
Is it ready for?
They have to file a compilation showing the each assessment year, what are the issues involved and what is the date of notices and what are the contentions raised by them and the case laws relied upon by them.
So finished whatever that is.
Yes, ma'am.
So when
They
do
have
you,
to start.
so when do you? Let us see. You get ready. We'll see. Relist on.
24th, my lord.
Huh?
25th.
25th.
Yes, ma'am.
Can it be 24th? 24th.
Huh? No, just. Where is it?
Lordship, let there be direction to file.
3rd of March.
Lordship, let there be direction to file the advance compilation so that we can give replay.
If there is any compilation, we serve.
Any compilation is filed by the petitioner to be
Yes, ma'am.
served in advance to the other side. Yes.
My lords, may I mention item 27 of list 1?
Yes.
My lord, these are 5 writ petitions pending for 5 years, my lords. I have moved a memo citing urgency as well on Monday in the applicable format. My lords, the urgency is that the current financial year that is going on is going to end on 31st March. I deposited about 1500 crores pursuant to the order of this honorable court on the assurance that the both parties will help in disposing of and assist the court in disposing of these matters before the financial year ends. My lords, they have filed their statement of objections. We have filed our rejoinder. Pleadings are complete. This is absolutely ripe for hearing.
Let us see. Let us see.
My lords, my only indulgence is because learned ASD and Venkatraman is also appearing from the other side. My lords, if this can be taken up at 2:30 today, senior counsel is appearing from our side as well. The issue involved is entirely covered by the division bench's order as well as my lord's order.
It may reach earlier only.
My lords, if it reaches earlier, we'll take our chance. But I just wanted to
I
take
have,
this.
I have a dictation at 2:30. After that, I will accommodate.
Very well, my lords.
If it reaches early.
I'm so grateful. I'm so grateful.
Your Lordship,
One aside. Never take what the judge says as an assurance without you applying your independent mind. Aside,
I'm so grateful.
That's an aside. I followed it when I was a lawyer.
I'm so grateful, my lords.
To the T, I followed.
My lords, in fact, there's a specific order.
We'll see.
Yeah,
We'll see.
very grateful.
as far as our reply is concerned in these cases, my Lord, ASD Venkatraman is having difficulty today. He has requested for reply on 16th, my Lord.
We'll accommodate. Let them start.
Very well, my lords.
We'll accommodate.
Please.
Yes. Next.
Grateful.
Give it.
Issue 2, fresh matter.
Give it.
Serial number 1, Pradyumna.
Huh?
The list, Your Lordship.
This
is pertaining to a dispute pertaining to RMC in GST, Your Lordship. I am a builder. I have entered into a joint.
What is the urgency that you can't wait till tomorrow?
The GST, no, Your Lordship. The GST notice has been sent through WhatsApp to me saying that they are going to freeze my bank accounts and take for attachments. Through RMC, I have paid my share of the property. Through RMC, the landlord share also they are asking me to pay somewhere around 1 crore 45 lakhs, Your Lordship. And that is the
Is state or central?
state, Your Lordship.
Yes, Hem Kumar. Just you give him an extra copy. We'll see.
Please, Your Lordship, at the end of the list.
No, but what is this end of the list?
The extreme urgency is that, Your Lordship.
That didn't is the urgency is was it not known yesterday?
Your Lordship, the yesterday whole day I
Give
prepared
it.
for
Give it. We'll
end
take.
of the list.
So you give an extra copy now itself
I shall
to
now
Hem
itself.
Kumar. Yes.
I shall now itself, Your
Yes.
Lordship.
Fresh matter.
Yes, sir.
Fresh matter, serial number 1, Pradyumna.
Yeah, these two. Yes.
Lordship, the short issue involved in this petition is that, Lordship, petitioner filed an appeal before the appellate authority. And appeal has been come to be dismissed on the ground that he had not complied with the pre-deposit condition, Lordship. In fact, whatever amount was liable to be pre-deposited, he had defaulted at a different head, that's IGST. And the appeal was taken on record, Lordship, with this payment. Subsequently, appeal was rejected, and I paid this amount again, I also, Lordship, 1,87,000, another 27,000, around 2 lakhs, I paid the entire amount again. And I sought restoration of the appeal, 2-3 mails I sent to Lordship. The appeal has not been restored. Now, Lordship, a recovery notice was issued earlier that was withdrawn. Now again they have initiated recovery. The short issue, Lordship, is that the appeal has to be restored to such authority. But again, I made the pay deposit.
So where is that second time payment?
Lordship may come to page number 74.
Page?
74, Lordship. These are the debits, DRC 03, Lordship. Page number 74 to 76, Lordship. I made it again, second time payment.
No, this is equivalent to the statutory
Please,
deposit.
Yes, please. 10%.
Now, where is your appeal?
My appeal is, Lordship. Yes.
Annexure?
Order passed. Appeal is at point number 45, Lordship.
Now, this is the appeal that was dismissed because of non-payment.
Non-payment. Although I had made the payment in different head.
Yes, now this appeal you have sought for revival.
Revival, Lordship. That's a short issue.
Any representation you have made?
I have made the representation starting, my mails have been sent to Lordship, starting from page number 78 to Lordship. 78. 4 mails I addressed, Lordship.
Where is the impugned order which is subject matter of appeal?
Annexure EU, Lordship.
Annexure?
Annexure E. 71 is the operative portion, Lordship, the order portion.
Which is a provision?
Section 107, Lordship.
The petitioner has sought for issuance of a writ of Mandamus, sought for an appropriate writ to set aside the order in appeal at Annexure E. Full stop. Petitioner has also sought for a direction to respond number 1 to restore the appeal and pass orders on merits. In light of petitioner having subsequently paid statutory pre-deposit as envisaged under section 107. One not 7 6B is it?
Oh, please, Lordship.
The petitioner submits that he had filed an appeal challenging the order in original dated 20th October 2020, isn't it?
Please.
Before the appellate authority. Also, it submitted that the statutory pre-deposit in terms of section 107 6B.
Lordship, dismissal is
No.
proviso to 107.
Deposit.
Please. 6B, Lordship. 6B. Please correct.
Was mistakenly deposited under a wrong head.
Wrong head, Lordship.
And eventually the appeal memorandum, the appeal at Annexure E came to be rejected by order dated 6/12/21.
Please, Lordship.
Full stop. It's submitted that thereafter petitioners made the deposit in form GST DRC 03.
Please.
And made representation by way of email for restoration of the appeal. And the copies of the emails are enclosed at Annexure G series.
Yes, it is.
despite which till date the appeal has not been revived. The assertions on facts made by the petitioner have not been controverted by the other side. Next, in light of the admitted deposit in terms of 107(6)(b, as evidenced from the GST DRC 03, the dismissal, the order dismissing the appeal at annexure E on the sole ground of non-making of statutory deposit requires to be set aside, and appeal filed challenging the order in original dated 2010-2020 requires to be restored. Accordingly, petition is allowed. The appeal, is there any number of the appeal?
Appeal number, Your Lordship, it is restored. Annexure E carries the number, Your Lordship, it is in the top, Your Lordship.
File number?
Yes.
Huh?
File number, Your Lordship. File number.
According to the appeal bearing file number box A at page E at annexure E page 66 stands restored. Same to be taken on record and date of hearing fixed. All contentions kept open.
Please.
Learned Counsel Akash Shetty accepts notice for the respondents. Yes.
Serial number 2, Vijay AM. Serial number 2, Vijay.
My lord, I represent the petitioners in this matter. I'm seeking for a mandamus, my lord, for consideration of my representations. Sorry.
Learned Counsel BDA. B. Vachan is directed to accept notice for respondent 2 and 3. AGA for first respondent lists the matter in the preliminary hearing list on
23.
Yes.
Serial number 3, Vishal Tiwari.
Smuggling of gold medals. 199 grams of gold was. It was concealed medals. In the same aircraft, there was another passenger who was traveling. He was also caught with the concealed goods, about 290 grams. He has also come before this honorable court members, saying he was also seeking for the release of the gold. In fact, he had challenged the margin.
No representation. Let us see. No representation for the petitioner. Learned Counsel for the respondent has placed reliance on order passed in WP 19362 of 2023 and submits that the petition filed by a similarly placed SSC has been rejected, and in the present case also petition deserves to be rejected on similar grounds. However, there is no representation on behalf of the petitioner. It's made clear if the petitioner remains absent on the next date as well, petition would be dismissed for non-prosecution. Relist the matter in the same stage on 18th.
4. Serial number 4.
I request for a small accommodation in this matter.
When do you want?
Week after next, kindly.
At request made on behalf of the petitioner, this is the matter week after next.
Please.
My lord, I filed a wakalat for R5. Maybe accepted, my lord.
R6, I think.
Before notice, I filed a wakalat.
R6,
Based
I
on the CCMS information given to the fifth respondent.
In fact, no notice has been ordered.
Let us see your name is being shown.
Yes, please.
Next date we'll see.
Please.
Yes.
5. Rajaram, yes. Serial number 5, Rajaram, yes.
Yes.
And the petitioner, my lord, we are seeking the writ of certiorari. My lord, I am filing the 28A application on 28/3/2006, my lord, but they have considered on 4/4/2025. But they have given
against an order under 28A, any statutory appeal? No. Okay, you accept notice.
Respondent.
AG accepts notice for the respondent. List week after next. Responding to complete
kindly fix the date,
instructions
ma'am.
and pleading.
Given a date, ma'am.
Date 2 weeks ಆದ್ಮೇಲೆ.
9th of March.
Yes.
Serial number 6.
ಅವೆಲ್ಲ week commencing from ಅಂತ ಮಾಡಿ. Change ಆಗುತ್ತೆ. February end change ಆಗುತ್ತೆ. ಇಲ್ಲ, those yes.
Serial number 6.
For the respondent.
Pass over.
7. Prasad K. R. Rao.
Now, this is a case where notice is being passed under 281, thereby declaring our sale deeds as null and void, my lord. The petitioners are the purchasers from the defaulter, who's the SSC, who's the respondent number 4 in this writ petition, my lords. The assessment year that has been, the order has been passed against is for assessment year of 2012, 13, 13 and 14, my lords. And as per annexure A, the annexure that we have asked for, seeking for quashing, is the annexure where they have notified in 2017, stating that the SSC, who is respondent number 4, has defaulted a sum of rupees 14 crores 11 lakhs 3,867, my lords. My lords, as per the facts, the petitioners have purchased the lands from respondent number 4 in the year 2014, my lords, as seen in annexures A to T, my lords. All other sale deeds.
Date of sale deed? Date of sale deed?
There are different dates in 2014, my lords.
2014.
14. There are different sale deeds of all the 16 petitioners from either the respondent number 4 or they are the second purchasers from the, they are the subsequent purchasers who have purchased from the first vendors from the respondent number 4, my lord. So he is the defaulter, he is the SSC, my lord. I have no knowledge about the proceedings being pending, or I have no knowledge about any of this notice that has been passed.
When was it crystallized? This demand of 14 crores.
2017, my lords.
Where do you get that?
Annexure A, page number 69, my lords. Annexure A. It is 24/10/2017. For the first time, they passed the order.
Now this is for recovery, isn't it?
This is for recovery, my lords.
So
And in
the proceedings of assessment.
Yes.
For those 2 relevant years.
Yes.
When did it culminate?
That we are not aware of, my lords. The order passed by the income tax recovery officer against the SSC is in 2017. And they attach my properties in the year 2025, my lords.
Where do you get that?
At annexure T, page number 398. It is in second volume, my lords. Annexure T series. Attachment Allah, order for SSC, order against SSC.
What is 281B?
280.
Attachment during the proceedings, provisional attachment. During the pendency of the any assessment proceedings, if the assessing authority is of the opinion, if the assessee is likely to evade tax, during the proceedings, it can be attached.
Just take me through the provision.
281.
281B.
281B, is it?
That is the provisional certificate, my lord, which shall have effect only for 6 months.
281 is the attachment during the proceedings. If any transaction taken place during the assessment proceedings, any proceedings before the income tax officer, that has to be treated as null and void. So, in this case, the proceedings, income tax proceedings for assessment year 2012-13 was started from 7/8/2013 by issuing notice under section 143(2). The sale deeds have been taken place from 10/1/2014 to 11/12/2014. During the pendency of these proceedings, Your Lordship, almost about 60 sets have been sold by the respondent number 4.
Just read to 281.
Yes.
281. ಅವರೇ ಓದಿ. 281B.
281 you read.
281.
Where during the proceeding of any proceedings under this act or after completion thereof, but before the service of notice under Rule 2 of the second schedule, any assessee creates a charge on or parts with the possession by way of sale, mortgage, gift, exchange, or any other mode of transfer whatsoever of any of his assets in favor of any person, such charge.
Just now, matter requires consideration. We'll direct them not to create third-party rights or make any encumber the property. And then we'll hear the matter, you take your pleadings.
Status quo may kindly be granted, my lords.
The petitioner submits that the petitioner is a bona fide purchaser for value from respondent number 4 without knowledge of the proceedings between the revenue and the fourth respondent. It's submitted that the attachment has been effected only subsequently. Learned counsel Sanmati, however, would submit that the transfers would be void in terms of section 281. However, in light of the contentions raised by the petitioner, matter requires consideration. In the interregnum, there would be stay of
Annexure A. T series, my lord, that is found in 398.
T series. While it's made clear that the petitioner is not to encumber the property or create third-party rights till the next date.
My lords, there's one submission with respect to the office objections, that is the service of notice to R4 may kindly be dispensed off with, because I seek no relief against respondent number 4.
Madam, 4 will have to answer. 4 will have to give details when notice is issued to R4.
Then I shall serve the same before the next.
We have not ordered for issuance of notice.
It is my lord.
Process fee to be
Yes,
paid
yes.
for issuance of notice to R4.
8, Pradyumna.
Yes.
Lordship, in 2010, remand proceedings were initiated by the Customs Department against the petitioner lordship. That show cause notice was issued in 2010 September, and it culminated in an order passed by the commissioner. That order was challenged before the Honorable Customs and Excise Tribunal lordship, which allowed my appeal with consequential relief. During these proceedings, I had deposited 16.45 lakhs out of an amount of around 55 lakhs demanded from me. So this was liable to be refunded to me. I accordingly filed a refund claim, lordship. The refund claim has been returned back on the ground that I should prefer it on the ICE gate. There's a portal called ICE gate, your lordship. On that, the problem with ICE gate, your lordship, you have to, if at all somebody is operating now, he has to update his import-export code. He has to register under GST. The company is closed in 2014. So he cannot, it's not possible. The direct managing director himself who is operating is 76-year-old. He's closed business in more than 10 years back. Lordship, there is a board circular which says that while it mandates that all refund claims shall be filed electronically, it also provides that in exceptional cases, as the commissioner may accept in writing, may allow the claim to be filed in manual. Probably to cater to such needs, it has been issued. So he is not justified in returning. I am seeking a mandamus, your lordship. Page, this lordship, page number 85, your lordship, board circular. Page number 85, bottom, your lordship. Shall I read, your lordship? Bottom.
Yes.
As a transitional measure, applicant may file the refund claim either manually or online, modes till 31/3/2025. However, no manual refund claim shall be accepted after 31st March 2025 unless the same is allowed by the concerned principal commissioner / commissioner of customs for the reasons to be recorded in writing. So this is the reason he can record ownership, because he is not in business.
Annexure A is the commissioner's order where he has specifically rejected their application. my lord.
This is what we are challenging. Lordship. It was not justified because in such circumstances, he cannot now operate.
There a reference to that circular, he's relying on some circular.
Please, my lord. It is
5 of 25.
Yes, it is. There is a reference one. If the bottom para 3, if you lordship looks at it, my lord. Hence, it is requested to file the refund claim online as per circular 5 of 2025, dated 17/2/2025, issued so and so. So it is further brought to your notice that after 1/4/2025, no manual application are being processed.
Now, he has to take that stand and we have to pass an order on merits.
Yes, to simply, he is entitled to refund. That is no dispute. Only way of mode of filing lordship, because he cannot take a GST registration. He cannot
have it next Tuesday or Wednesday, my lord. By that time, I'll even take.
Learned Counsel Arvind Chavan accepts notice for the respondent. This is the matter in the preliminary hearing list on next week. Yes.
Right. Serial number 9. Mahesh, YL.
9, 10, 11, 14 and 16 are yesterday's matters. 10 and 11 would be the matters where I read the interim order, lengthy interim order. I think those would be serial numbers 10 and 11. 9, 14 and 16, my lords, I'll have to make some submissions. I also applied my mind, but 10 and 11, my lords, if my learned friend could make a submission, because it's identical to the matter which I read out yesterday.
Yes, detailed interim order.
Yes, very detailed.
Yes. Yes, same Kumar. 10 and 11 could. 10 and 11.
Disposed of.
With the same order.
10 and 11.
So there is a genuine reasonableness for the delay. Well, this has been considered by learned citizens in other matters. I'd only like to place on record, Malaj, this expedition number 1495 pertains to vehicle number 741, Indian 741. The delay, Malaj, I have explained. It's because of bona fide reasons. From the date the vehicle was intercepted, knowledge have given the list of events.
No, correct. What we could do is, in terms of division bench order, pass that order and keep it pending and club it with that matter.
Single judge, not division bench. Single judge.
Counsel would not be agreeable with the order passed by the division bench.
Single judge.
These two matters he wants order passed by the single judge with regard to deposit of 200%.
What is the
other matters, Malaj, I would have insisted. Because genuinely there is a delay in conducting physical verification.
in these two?
I have explained, Manoj. On 1911, Manoj, the goods was intercepted. From that day, Manoj, we have been interacting with the officials in Delhi and others to verify the genuineness of the transaction. It was only on 17/12/2025, Manoj, serial number 20. We have gotten a verification report from the Principal Commissioner, Delhi North, saying that the arbitrators will be considered as a existing but non-operational, non-functional firm. And immediately thereafter, Malaj, we have conducted the physical verification.
Now we'll consider. So we'll pass the order and he'll give anyhow, he's going to give indemnity to the value in terms of the report of the entity and the director of who.
10 and 11.
10 and 11.
10 and 11. Regard to, apart from the 200%, my lords may kindly secure it, because in one of the matters, my lords had asked them to furnish property security. Till today, they have not been able to do it because there is some problem with regard to valuation, with regard to the property. Market value has to be taken on.
So we'll just see. The only thing is it has to be secured.
Yes.
In other matters, Malaj,
How? Just wait. First 10, 11 will be. Now where is that order?
That was a part of the case compilation, my lords, I handed over. Yesterday across the bar I handed over.
been brought out report. Impugned order has not been brought out. Serial number? Serial number?
10 and 11.
No, no. In your compilation.
Oh, in the compilation, the first order.
That's from page 1.
Order dated 19/12/25 in WP number 37627.
Operative portion is at page 8.
Now, how do you intend to secure this? Apart from indemnity bond?
Yes, ma'am.
Now you are an entity proprietor or who is?
Is it, what is it? Proprietorship.
Proprietorship. So how could you, now the value of the goods,
Yes, ma'am. Now, can I just make this
Yes,
submission?
yes.
In any
Yes.
event, the writ petition is pending. If I can understand if it was disposed of, there is a genuine chance possibly, because I agree that, I will escape from the clutches of the law. We are before your lordships. It's an interim arrangement. So since the writ petition is pending, your lordships may consider relaxing that.
Some point has to be your. After the matter is kept pending for a year, after that petition for all reasons withdraws the writ petition, then perhaps we are left nowhere.
so what is the security you suggest?
That problem we are facing genuinely. Matters in case of Karnataka, where we got permission from the court to auction that and keep the money in the treasury, which we did. 2 years later, the petitioners are not appearing before the court. Now we are able to trace it.
So what is the, as per the valuation report, what is the value?
It's to confiscation order.
Confiscation. I need the confiscation.
Confiscation order, even that we need to produce that. Along with the amendment application, would have produced the confiscation order.
No, now I'll have it tomorrow.
Yes.
You just find out how you could secure it.
Very well.
However it is. And then
No.
we'll pass an interim order. The remaining matters will fix a date and hear it.
Very well. 9, 14 and 16. Like if I could request on Tuesday, because I have some submissions to make. What has happened? Anyway, I'll reserve my. I'll on Tuesday.
So 9, 14 and 16 we'll have it on Tuesday. We'll de-link it and have it Tuesday. It's de-linked.
No, it's not linked in any event.
Huh?
It's not linked.
9,
14 and 16.
14 and 16 relist on Tuesday.
10 and 11 will make
10 and 11 relist tomorrow.
Tomorrow, well. Seventeen. Serial numbers correct again,
Yes.
Okay.
17. For
77. Grateful.
So it's posting this only for consideration of interim order or?
Yes, only 10 and 11 for it. Yes.
I don't think they should also have a dispute with regard to publishing 25%.
No, correct. So what they're going to do, let them find out what form they're going to give it. To secure the value, whatever valuation report is there, how you could secure, you get instructions and so.
I'll get it.
Yes.
12, Prasanth Kumar HT.
Covered by judgment, another claim kindly be seen notes. So after executing the sale deed, some modification of plan is modified. It has been already questioned.
Page,
my lord, the 45, my lord. 44 notes. Operative portion of the judgment, 49.
On what is the?
Well, the society has executed the sites in favor of the member. I am the subsequent purchaser. He sold the same site in favor of me. After purchasing, some layout plan has been modified, which cannot be done. Hence, same is quashed by the court divide and exit came launch.
You take out notice.
Please.
Learned Counsel Shri K. Krishna is directed to accept notice on behalf of the respondent 1, 2, 1 to 4. Yes, relist in preliminary hearing list on.
23.
Yes.
13, serial number 13, Sachin BS.
Yes.
Lords, the appellate authority, my lords, revisional authority, my lords, without giving an opportunity. Lords,
Yes,
has
who
passed
appears
the-
customs? Customs. Yes.
My only ground, my lords, that principles of natural justice, my lords, is not followed. Lords, an order, my lords, passed by the revisional authority, my lords, without an opportunity, my lords, is, my lords, passed directing, my lords, me to give refund back, my lords, 3,32,000, my lords, of amount, along with penalty. Lords, may see annexure A, my lords, the paragraph 4, my lords, page 20, where, my lords, the revisional authority also, my lords, says that, lords, I got to know, my lords, about this order only after, my lords, the.
Correct. So what is your answer now? Suppose we were to remand. What
Please.
is your prima facie answer to that?
Para 4 of the order, personal hearing has been extended 3-4 times.
Correct. So on merit, suppose we were to send it back. What is your explanation for that?
Lords, on the ground, my lords, that the custom authority, my lords, have said that, my lords, the cash that I was carrying, lords, I have admitted that, my lords, have not given any document to them. Lords, I say that, my lords, it is from my employment, my lords, that I have taken out 4,600 euros that I was carrying while traveling. Lords, which amounts to 3,32,000. Lords, the appellate authority, my lords, reverses the order of the custom officer, saying that, my lords, under the law, they are entitled to carry out, my lords, carry the certain amount, lords, under law, and reverses the order of the custom officer. Custom officer, my lords, goes in revision. There, my lords, this order, my lords, of the appeal, my lords, is overturned, and, my lords, I am directed to refund the amount again. Lords, the
Order in original, you did not participate.
lords, order in original, my lords, I participated. My lords, that is at, my lords, page 52, order in original.
Now this annexure is what order?
Annexure is, my lords, the revisional order. Lords, order in original, my lords, was against me. I went in appeal before the appellate authority.
Now it can be remanded to the revisional authority. You hear in letter.
I'll just take instructions.
Learned
Next Tuesday or
counsel
Wednesday.
Arvind Chavan accepts notice for the respondents. Relist the matter in the preliminary hearing list on 18.
Lords, until then, my lords, no precipitated.
Respondent not to take precipitative steps till the next date.
Yes, correct.
Small amount, so Chavan has no.
14 urgent, 15. Ramurthy R, 15.
Yes.
The petitioner, my lords, is a society. The plan was allotted as a partnership firm. By mistake, it was linked to the, and in fact, mistake, I would say that there was no difference between the name and all was same, and the assessing petitioner thinking that in the PAN, it was linked to the bank account. Later on advised, my lords, they have obtained a PAN in the name of the society as society, my lords.
So personal account.
It's not personal, it's
It
a
was linked.
partnership form.
No, it was linked to.
Society account, my lords.
Huh.
Society has recorded all the transactions in its books of accounts, my lords.
Huh.
Notices are issued in the name of the partnership firm, which is not in existence at all, my lords.
Society is not in existence.
Society is in existence. Partnership firm is not in existence.
So
Assessments are made in the name of the as partnership firm.
It was linked initially to the bank account of the
PAN issued as partnership firm was linked to the bank account. Later on, it is the PAN what was obtained later as society was linked. Your Lordship, they have filed appeal and the appellate authority has remanded the matter. Annexure F, page 44. Page 49 is the ending Miller operative portion. It has been remanded back to the, since it was ex parte assessment, they had not given any reply to the notices. Paragraph number 5 in the last. During the appellate proceeding, the appellant replied on so-and-so dates, but during the assessment proceeding, the appellant could not respond to the notices issued by AO, and there was absence of natural justice in adjudicating the cases. Therefore, as per the amendment to section 251 of the Income Tax Act, so with effect from 1st October 2024, the assessment order is set aside and the appellant is referred back to the assessing officer for making fresh assessment. Let them file reply to all the notices, my lord. It has been rightly sent back.
My lords, I am challenging the very initiation of the proceedings. The notice at Annexure B 25, my lords.
No, correct. Now it is the same, whatever you're saying, you raise it.
No, my lords,
On
in the
remand.
assessment proceedings, the notice itself is bad, my lords. 148 AB notice.
Not at this stage, after you have gone in appeal. Suppose you had not gone in appeal and come
Because,
here, you
my
would have.
lords, there is no existence of the partnership firm.
No, that may be so, but now you have already gone before the appellate authority.
No, that's a mistake, my lords.
No, that we can't. Now that we can't determine here. Now you go before the appellate authority, you place whatever your case.
Appellate authority has dismissed and it's in the process of second assessment proceedings, my lords. Please let it be set aside, my lords.
It has been set aside, my lord. He has to go before the assessing authority and file reply.
No,
the appellate authority has remanded.
Set aside, my lords. Please, I'll file a reply to the notice under 148 AB.
Where is the appeal order?
Your lordship, page number annexure F, my lord. To give reply only, it has been sent back. Annexure F, page number 44, it starts with, and in the end, your lordship, during the appellate proceeding, the appellant replied on 207.
You read para 5.
The present appeal has been filed by the appellant against the assessment order passed under section 147, read with section 144 of the Act by the assessing officer so and so for assessment year 2018. The assessment order was passed ex parte on 14 to 2024, determining the appellant's total income of at rupees so and so, which was based on undisclosed income from businesses disallowance under section 48(3).
Okay, just there's nothing. You go there.
It has been sent back and he has to give reply to the notices.
It has been reopened. What you're canvassing here, you can canvass there.
No, my lords, this is what is set aside is the assessment, my lords.
Yes.
My prayer before my lords is that 148 AB notice was issued to me. At that stage, I'll be able to canvass that the partnership, there is no partnership firm.
Now, whatever you want to make, you make in the reassessment proceedings are reopened. Now we can't go to that stage now.
Now, 148 AB stage I may be sent
No,
so that I can reply stating all that I have attached this.
Not after the appellate order. We can't now, before filing the appeal, you should have thought about challenging that AB order, not at this stage.
Now that I am informed that, my lords, even subsequently ex parte order has been made.
Where subsequent to?
In this, my lords, yesterday they have passed an order subsequently ex parte order.
That you find out.
That they have to challenge afresh, my lord. This will become infructuous.
No, because the notice is less than 7 days, my lords. It is notice 148 AB notice.
We can't revisit that at this point of time. After now, you find out what is the subsequent development.
Yes, ma'am.
I'll have it on next week.
Yes,
78 is also similar, my lords.
Accepts notice for the respondent. Relist matter in the preliminary hearing list on 23rd.
78 is also identical.
78 is also same as a similar.
List along with 78.
Please.
Yes.
Adjourn 17. Pradeep.
I appear for the petitioner, Your Honours.
Yes.
Your Honours, this is a case where the petitioner land was acquired due to pending partition suit. The award amount was deposited in the trial court under LSC miscellaneous petition number 42 of 2025. Now, Your Honours, what happened is the award was passed in the year 2021. Possession is taken in 2021. But the amount is deposited only in the year 2025 on 29/3/2025. I'm seeking
Yes, you
for
take out in notice.
Your Honor, Mr. Maluke is the panel counsel for respondent. Road Development
Third
Corporation
one.
Limited, right?
Manu K is directed to accept notice for the respondent. List the matter in the preliminary hearing list in the week commencing
2nd of March.
from 2nd of March. Yes.
18. Ravi Raghavan, 18.
Yes.
This challenge to a notice demanding interest.
Yes, who appears? Yes.
So demand of interest on tax that I paid on salaries paid to expat employees in 2022 pursuant to Supreme Court judgment. Subsequent thereto, there have been a series of decisions of judgments by this court in the bench of this honorable court. It said that no tax itself was payable in respect of such transactions. Because that Supreme Court in the case of Northern Operating held that these are taxable. So at that point in November 22, I paid the tax, took the credit immediately, no loss of revenue to the government. In fact, I had come up before this honorable court in an earlier proceedings in the same matter where common cause was issued by both the center and the state.
Where is the interim order in other matters?
In my own case, for the earlier period, there's an order, judgment passed by the honorable, by this honorable court.
Page
263 minutes. This very assessee for the same demands. The honorable High Court Manats passed the notices issued by the center on the ground of 62B, remanded to reconsider on the other points of input tax credit, etc. Page 267.
Similar demand.
Say this very demand, Manoj. In fact, I paid tax in November 22. They initiated, both state and center initiated proceedings demanding the IGST, proposing to appropriate demand interest.
Okay, you take your stand.
No, order is not passed, minutes. No, hearing has not been fixed, no order has been passed. In fact, we have told that.
Only at so-called notice. I have no instructions for the order has been passed.
You want to find out?
No, in fact, we are under instructions. Subject to any order passed. In fact, the
if any order is not already passed.
And counsel for the petitioner submits that the proceedings initiated under the show cause notice are not legally tenable and relies on the observations made in WP 26296 of 2023. Matter requires consideration. Light of the same will be stay of the show cause notice
dated 5/12/25.
dated 5/12/2025.
Next A.
And consequential proceedings. Full stop. As AGA submits that he is not aware if any order is passed pursuant to Annexure A, it's made clear that the interim order passed is subject to no order of adjudication having been passed. AGA accepts notice for the respondent. Pleadings to be completed within 2 weeks.
19.
Yes.
J. Goda L.
Obliged.
19.
Yes.
I'm a subsequent purchase in lots. I'm not challenging the acquisition proceedings in lots.
HL Pradeep Kumar.
I'm not challenging the acquisition proceedings in lots. Asking for only for compensation lots. After final notification of purchase land.
My lord, kindly pass over, my lord.
Now they have not deposited or they have
Not deposited lots. Even though they not take possession.
okay, find out. Relist on Monday.
Lots
Same stage.
until lots they not interim order may consider lots.
Now you think they may give it to somebody else, is it?
No, my lords.
Respondent
They are not passed, my lords. My lords, kindly see Annexure D, my lords. They issued a notice, my lords, for consent on 7/5/2025, my lords. For my vendor, my vendor, my lords.
Correct. But what is the interim order you want?
Not to pass an award in favor of my vendor, my lords. Respond number 7.
The No, but we don't know if award is already passed. That we have to find out. It's already more than 8 months since the.
Have it on Monday, my lord.
Huh?
Have it on Monday. my
Let us see. Relist on Monday in the same stage. If something is done, we'll see what to do.
Lords, until lords,
We will see what to do. We'll have it on Monday. If some orders passed, we'll pass appropriate orders.
please.
Relist on Monday in the same stage.
20,
Yes.
Aditya, but 20.
May it please your lordships. Well, its challenge is to the assessment order, minutes.
Yes, who appears? Income tax. Yes.
This challenge, minutes, is to an assessment order, minutes. Under section 147, read with 144 minutes and consequential penalty recovery proceedings minutes, and the freezer of my bank account minutes as recently as November 2025, and the freezing of my bank account minutes as recently as November 2025 minutes. Minutes, it relates to the assessment year 2020-21 minutes. Now, my lords will see in respect of the same set of transactions minutes, both my wife and me received notices minutes in January and February 2024 minutes. My then CA minutes is instructed to file replies both on behalf of my wife as well as me minutes. Now, in respect of my wife minutes, a reply is filed. However, in respect of me minutes, possibly by oversight minutes, no reply is filed. May I just draw my lord's attention minutes to the acknowledgement received in respect of my wife's reply, which is at page 81 minutes.
Page
81 minutes.
Yes.
Well, it's page 81 minutes.
Yes.
Well, it's under the remarks column. I filed the ITR for the annual year 2020-21 with the e-filing acknowledgement number so-and-so dated so-and-so. I am writing to provide an explanation regarding my financial situation during the COVID-19 pandemic, which has significantly impacted my income and financial stability.
Your
Leading to
wife's.
This is my wife's, minutes. Just the next line is important, minutes. During the pandemic, my husband Kunal Chaube, PAN number so-and-so, unfortunately had to incur businesses which led to closure of his company, CH-08 Technologies, due to economic downturn, leaving us without a steady source of income. This period was marked by a significant financial distress as we struggle to meet our basic needs and financial obligations, minutes. Minutes, I'll skip this portion, minutes. If my lords comes to the 7th last line, it says, till that point, minutes, they describe the financial situation. They then mention the situation escalated as I began receiving daily calls from recovery agents, adding to stress and urgency and financial dilemma. In an attempt to mitigate this issue and manage the mounting debt, I resorted to paying off the debt of one or more credit cards with another, creating a cycle of debt that became increasingly difficult to break. Now, Millards, I just want to pause here, Millards. What happens in the year 2019-20, Millards, the financial year, the petitioner, Millards, gets into a vicious loan cycle, Millards, because his company closes. He has to pay off debts, Millards. So he uses his credit limit, Millards, to basically avail loans. Now, the website from where he basically avails loans, Millards, has a requirement that the money will not come to his account. So the money then goes to his wife's account, Millards, transferred from his wife to him, and then he pays off, Millards, these amounts, Millards. Now, the tune, Millards, of payment is to the extent of about 1 crore 8 lakhs, Millards, in credit card bills. Now, this has been termed as unexplained expenditure, Millards, and income that is chargeable to tax, Millards. That is my first limb of submission, Millards, that there seems to be a bona fide error, Millards. Possibly I should have been more vigilant, Millards, but my CA will also, possibly by oversight, Millards, did not submit a reply, Millards. Now, Millards, that is one aspect of the matter, Millards. Millards, the second is, Millards, is in respect of the variation that has been noticed in the assessment order, Millards, a glaring error. If I may just draw my lord's attention to page 88, Millards, which is a variation notice. Now, Millards, at item 2, Millards, Roman serial number 2, further the payments of rupees 1 crore 8 lakhs made for credit card bills, Millards, for the financial year 2019-20 should be treated as unexplained expenditure, Millards. my lords will note that, my lords, serial number 2, my lords, it's 1 crore 8 lakhs, my lords. Now, my lords, in the assessment order, my lords, if my lords comes to page 43, my lords, for a moment.
Yes.
My lords, at Roman numeral 2, my lords, as opposed to treating my payment of HDFC credit card bill to the tune of 10 lakhs 8,000 minutes, they treat it as 1 crore 8 lakhs minutes accidentally. And then in the computation sheet, minutes, it's taken that about 2 crores 8 lakhs minutes has been paid towards credit card bills.
No, the payments made is 1 crore 8 lakhs.
Please, minutes. In respect
88.
of, please, minutes. In respect of all credit cards, minutes.
Correct.
Now, my lords, if my lords comes to the assessment order at 43, it ought to have been 1 crore 8 lakhs for all my credit cards. However, my lords, there seems to be an oversight where they say in respect of HDFC card, I have made a payment of 1 crore 8 lakhs. And then, my lords, they go on to explain in respect of the other credit cards, my lords. So there, my lords, there is also a computation error. My lords, my only difficulty is this, my lords. I am the breadwinner of my family. My father is ailing. My accounts have been frozen, and I was brought to notice of the freezer, my lords, only in November. Now, again, my lords, there is another fault at my end. My new CA, my lords, files a condonation, my lords, after the account is frozen, my lords, at page 79. This is, my lords, in December.
In all cases, only if auditors are to be blamed.
No, my
I
lords, not
pity
at
the
all.
auditors.
Not at all, my lords. I wouldn't.
No. Later when I'm saying.
Page 79, my lords.
Yes.
Now, my lords, the reason why I've come to court, my lords, after 3 months, and I ought to have come in November itself, is because, my lords, my new CA says that I will file a condonation. My lords, that condonation, my lords, will see is at page 79. And then, my lords, in January, they're told to basically move the court, my lords, as opposed to going before the authority again.
Yes. Tirumalesh.
Matter is of a recent, but they have gone in 119 instead of exercising fundamental natural principles of natural justice at the first time itself.
119 is?
11, they have gone approach the commissioner for condonation of delay for AY 2021.
20, assessment of 2020.
No, this order is for which year now?
Well, as this order, my lords, the assessment order is dated 30th January 2025. I am not intimated.
For which year? For which year?
For the assessment year 2020-21.
This is of a recent order, the 1-year-old order.
No, correct. Now you sought for condonation to file a return.
Yes, my lords, to file a return, which possibly is not the correct, my lords, approach. So I just pointing out, my lords, why there is a delay at my end, my lords. To have come after November, I ought to have come immediately.
Yes, Tirumalesh. What is it? You want to take instruction or what?
Because since they have gone in 119, the commissioner get the jurisdiction, he has rejected the application.
No, my lords, he's not considered.
He is not.
It's not even considered, my lords. There has been no reply to us
whatsoever. You have filed
my lords.
application.
Please, I'm only pointing out, my lords, that the delay at my end is because of this particular document.
It can go. It has to go back, because 148 notice has let them file return to in response to 148.
So this S could be ignored.
Pardon?
S could be ignored.
Yes, that application they have filed for condonation of delay was not required.
Yes.
My lords, may I also request, my lords, that my accounts which are frozen, my lords, may be defreezed.
Once the order goes, that automatically goes.
It's mentioned, my lords, because my company has refused to credit my salary as well. That's the only reason, my lords.
The petitioner has sought for setting aside of the assessment order at Annexure D dated 30th of January 2025. Is a case of the petitioner that due to undue hardship relating to financial losses during the COVID pandemic, the petitioner was forced to repay debt by making payments through credit cards, and such payments have been deemed to be unexplained expenditure and proceedings initiated. It's submitted that due to bona fide lapse arising out of reasons which are genuine, petitioner was unable to make out reply to
It's my show cause notice,
the show cause notice.
Yes, under 148 AB, which is at page number 13.
Under 148 AB to the note show cause notice to 148 AB, which is culminated in an order in 148 AD, and subsequently 148 notice was issued. No, that's the correct procedure.
Pardon? Yes, no.
No, after 148, he is required to file his return under 148.
Yes, he has not filed even.
No, then the condonation is correct procedure.
No, that is true, my lord. But since principles of natural justice he is contending, could have directly come before the court after the assessment order.
No, so now to which stage it has to go back now?
He has to go back to 148 AB stage or 148 notice to file a return. Either way is okay.
Full stop. It is further submitted that the entirety of the proceedings would not have culminated in an order if the petitioner had made out a reply to 148 AB notice itself. It is further submitted that the discrepancies in the variation proposed. Full stop. It is submitted that the 148 AB notice, which details information, would prima facie reveal that the subject matter of proceedings was relating to payments made from credit cards. Full stop. Accordingly, it is submitted if the matter is remitted to the stage of 148 AB, the petitioner would be in a position to explain. Learned Counsel submits that the SSC has made out a petition to the Commissioner seeking condonation of delay for filing of return as regards which no order is yet passed. Next. Heard both sides. It is the case of the petitioner that he has substantive material to make out reply to 148 AB notice, and having perused the notice at 148 AB and the annexure, the explanation of the petitioner that is made herein, if made before the authority, it would be appropriate for the authority to consider the same. Notwithstanding that the petitioner has sought for condonation of delay in filing of the return, but accepting the contention of the petitioner that he needs to be given an opportunity to make out reply to 148 AB notice. In light of the contention raised, it would meet ends of justice in setting aside the order at annexure B and remitting the matter back to the stage of reply to 148 AB notice. Full stop. The consequential proceedings at annexure C, D, E, F, G, H, J, K, L, M, N, and P are set aside. Full stop. Consequent to the order passed, the respondent authority to rescind the debit freeze instruction made to the banker of the petitioner. All contentions are kept open. Now we fix a date or faceless? Faceless.
No, the one AB, it goes to the stage of the JO, the jurisdictional assessing officer, not faceless.
Petitioner to appear without fresh notice before the jurisdictional assessing officer and make out reply to 148 AB. Full stop. Petitioner to pay costs of rupees 10,000 to clerk's welfare. Clerk's welfare. Yes.
These are bank account that's at annexure R.
Huh?
The communication is at annexure R. That's,
Which one?
because these are my bank account, page 75.
The officer is directed to immediately release all the bank accounts. It's quite automatic.
And accordingly, the authorities to take appropriate steps to rescind the instruction at annexure R within a period of?
The moment they receive, they will do it, because they have bound to do it.
Upon receipt of certified copy of the order.
21.
Land Council Thirumesh accepts notice for the respondent. Yes.
21 Ramurthy R.
This I am challenging the 148 notice issued by the jurisdictional assessing authority and sanctioned. There is a PCIT sanction is obtained instead of the PCCIT, my lords.
Yes, first time.
Your Lordship, first time, my lord, this ex parte assessment order, they are not contested. The annexure D, the notice is bad, my lords. Assessment order is passed under section 144, 147, read with section 144. Multiple notices have been issued. Let them file page number 20. Multiple notices have been issued. They are not appeared, my lord. And in the petition copy, it has been stated that the consultant had received the emails, but they could not give respond. He has not informed. Page number 4, my lord, paragraph number 2, pleading, my lord. A notice dated 23/3/2003 came to be issued under section 148 AB of the Act by the first respondent by way of page number 4, my lord. Petition copy, averments, my lord, pleading, paragraph number 2. They have admitted that notices have been issued by the consultant and he has not informed them, they could not appear. Show cause notice sent to email, which is the petitioner's consultant. The petitioner does not operate e-filing portal and is generally operated by consultant for filing the return of income. The consultant did not inform the petitioner about the show cause notice.
Yes.
Notice is issued based on the withdrawals made in the bank account. The information for sending the show cause notice, page number 15, my lord, information. Let it go back to the stage of 148 AB notice, my lord. Information at annexure, my lord, page number 15.
Yes.
Cash withdrawals of 1 crore, class B.
Correct. So to what stage?
Your lordship replied to 148 AB. Let them pay cost of some amount, my lord.
Yes. And this next time I'll direct you to implead the auditors. I'm really, I don't understand, but in every case, if the auditors are the punching bag, there is something wrong. You can't simply defame one whole profession only. Either you have to pay him well and look after him well. The Land Council Sri E.I. Sanmati accepts notice for the respondents. The petitioner submits that the now order is also passed, is it?
Yes, assessment order, final assessment order. Annexure D is the impugned order, my lord. Assessment order, penalty order is at page number annexure D.
Challenge the assessment order for the year 2018-19 and submits that the entirety of the proceedings were ex parte. It's further submitted that the proceedings started with the notice under 148 AB and the information made out was with respect to cash deposits and cash withdrawals. It is submitted that the said information could be explained and petitioner has information regarding information and material to explain the same. Now, how do you explain this?
I like to look into the bank statement.
Huh?
Bank statement.
No, if I were to send it back, you must have something in
Because
mind.
Bank credits, my lord, sir. The information is, it relates to the business bank account.
It is submitted that the cash deposits and withdrawals relate to business transactions.
Yes, my lord.
Full stop. It is submitted that the lapse was only because of auditor not having informed the petitioner about the show cause notices. Full stop. In light of the fact that the proceedings have ended in ex parte order, and in light of the assertion of the petitioner that they have material to explain to the 148 AB notice, it would meet ends of justice by accepting the bona fide lapse and reopening the proceedings. Accordingly, the order at Annexure B is set aside. Matter is remitted to the stage of reply to 148 AB.
Yes, ma'am.
Petitioner to appear before jurisdictional assessing officer without further notice on 2nd of March.
Yes, ma'am.
Consequently, other orders at Annexure C, D, E are set aside. C, D, E and F are set aside. Petitioner to pay costs of rupees 10,000 to so and so. Yes.
22, Virupaksha PH.
That's the petitioner had filed an application, my lord, under section 28A, my lords, of the Land Acquisition Act. That's the third respondent authority, my lords, by award dated 2/12/2024, my lords, at Annexure B, my lord, had redetermined, my lords, the compensation payable in favor of the petitioner. My lords, if your lordship kindly peruse page 28, my lord. While awarding statutory benefits, my lord,
You're filed within time.
it is within time, my lords, an award is also passed, my lord.
Let them find out.
Lords, the
Award
award is also passed. However, my lords, only in respect of the land, my lords, the statutory benefits, my lords, has been granted. In respect of the acquired trees, my lord, the statutory benefits, my lords, of 30% solution, my lords, and also 12% additional market value, my lords, has been denied, my lords, by the third respondent authority. That, my lords, is contrary, my lords, to the judgment of this honorable court, my lord. I have also annexed, my lords, the judgment, my lord.
Page,
my lord, page 33, Annexure E, my lord. Lord, at page 40, my lords, if your lordship kindly peruse, my lord. The issue was, my lords, whether the, my lords, at page 40, my lord, these appeals are filed challenging the judgment and award passed by the reference court, questioning the enhancement and assessment of compensation for yield of trees, as well as questioning the calculation and on solatium, additional market value, and award of interest. Lord, this honorable court, my lord, if your lordship kindly peruse, my lord, the page 57, my lord. By following the...
I think 28A applies even to trees.
Lords, the benefits, my lords, under section 23, my lord, of 30% solatium, my lords.
Let us see, AG accepts notice for the respondents. Respondents to take stand in writing within 2 weeks. This is the matter thereafter.
23, Ravindran P, 23.
Yes.
Petition in this case. My lordship, the petitioner is the owner of site number 6, formed in survey number 52, converted survey number 52. Annexer A, my lordship, may kindly see at page number 70. My lordship, may kindly see annexer.
Now they're seeking to form a road, is it?
No, they already formed.
Huh?
See, if my lordship kindly see annexer G at page number 50, in 2017, they issued a notification about the requirement of land for the formation of road under section 14B of the Karnataka Town and Country Planning Act.
No, now they've already utilized.
Already formed the road. Now, lordship may kindly see, there was a writ petition. My adjoining site owners, they filed a writ, your lordship will find that annex L. This was filed in 2018. They trespassed on the property, taken forcible possession, no acquisition, nothing. This matter went on contempt before the Honorable High Court. Your lordship will find thereafter, as per the direction of the Honorable High Court in the contempt petition, they issued the annexer M, preliminary notification.
Page?
At page number 66.
Now in that your property is
my property is not there. They keep on telling that you will be included in that.
They won't.
No, that is what
Take out notice. Who appears in those matters? In the last round, who appeared for the authorities?
Manesh Kumar. Monesh Kumar.
Third council. Prashant Chandra also appeared.
No, actually Monesh was.
Monesh Kumar.
Monesh.
Third council, Monesh Kumar. Directed to accept notice for respondents
2 and 3.
2 and 3. AGA for the first respondent. This is the matter in the preliminary hearing list.
Anyone date make any?
On. ಇನ್ನು ಒಳಗಡೆ ಕೊಡ Ninth.
24, Sharon.
Right, I appeal for petitioner. So quashing of general award, my lord, which is annexure E, page number 24.
Award, consent award, is it?
Please, my lord.
This can't we get some solution to this?
No, my lord. Once, my lord, as soon as, my lord, the general award is passed, the office of the SLO becomes one touch officio. Or he cannot reopen. Only, my lord, court can, my lord, has to, my lord, set aside that order, my lord, then, my lord.
Council Shri HL Pradeep Kumar accepts notice for respondent 2 and 3. AGA for first respondent. Repeat para 2 till end. And repeat 36627 of 25.
Is produced, my lord, similar order, page number 5.
Same one.
That is.
Yes.
Please.
25.
Grateful, my lord.
And before your lordship's not questioning the show cause notices and impugned orders passed under section 74 of the GST Act, but on 3 grounds. One is that common show cause notice is issued for 3 years, and despite the reply and the judgments given by this honorable court, that the respondent has said there is no bar under the act. Secondly, Lord, the denial of ITC, Lord, is the only.
That issue is still to be decided.
It is to be
It's
decided.
listed on 18th.
Huh?
Listed on 18th.
Where is that show cause notice?
Lord. Show cause notice, your lordships will get it at annexure D.
42.
40.
That is that Pramur, is it?
Parmur Home Centers.
Petitioner submits that show cause notice relates to multiple tax periods, which is impermissible in light of the judgment order of this court in Farmwood Homes and Shelters, so and so. In light of the same matter requires consideration. In the interregnum, there would be stay of
Lord, annexure D and FG.
annexure
F and G, Lord.
F and G.
Please.
And Lord Counsel Arvind Chavan accepts notice for the respondents.
I've given
26.
notice to chair.
Yes, yes.
Received.
May it please your lordships.
Yes.
My lords, I'm engaged in these matters. There are two issues that come up here, my lords. Issue number
Central
one.
tax. Just 1 minute. Central
Yes.
tax.
Central tax, my lord. Central tax.
Copies.
Copies have been served already, I think, my lord.
No.
It's not served on me, maybe on the department.
Yeah,
On the department. My lords, the first issue that arises here, my lords, is just what your lordships already considered. Pramur Homes, where the show cause notice has been issued for a consolidated period of years. Please come
Show
to
cause notice at page.
page, my lords, will start
My
from
lord, interim
124.
order.
124 it starts. The relevant page, my lords, will be 158. Your
Now the
lordships,
multiple tax periods are
April 2018 to March 2024. Please see para 8, first paragraph.
yes. So let us see. You take find out.
I'll take it.
There are other grounds also, my lords. The two judgments of this court has covered it in educational institutions. I think Mr. Arvind Chavan will be very much aware.
Let them get instructions.
I'll seek instructions. On the question of common show cause notice, your lordship can stay.
Then senior counsel appearing for the petitioner submits that this is a case of a single show cause notice relating to multiple tax periods spanning from April 2018 to March 2024. And in light of the judgment of the coordinate bench in Pramur Homes and Shelters, so and so, the such show cause notice is impermissible. In light of the contention raised, there would be stay of
Annexure A, my lords.
Annexure A and proceedings pursuant thereto. Non-counsel Arvind Chavan accepts notice for the respondent.
Lordships may, if found fit, also mention that it's covered by the writ appeal decisions which are there on educational institutions. He can take instructions and file. My lords.
Other contentions have been raised, including that the subject matter on merits is covered with the order passed in WA number.
My lords, in Bangalore North University's case and Gujarat High Court, the Bangalore North University is our own case, my lords. And
that citation, one you just said.
Yes, my lords. I'll just give the Gujarat High Court decision in educational initiatives, my lords.
In the case
educational initiatives versus Union of India.
Educational initiatives versus private
Union of India, my lords will find that in
2022-63 GSTL 45.
Yes, my lords.
Yes.
Deeply obliged.
Finally. 27. Tirumalesh M.
On this service tax matter, my lord, there is a Chinmaya trust issue. Where the notice was issued.
Want to check how we can do?
My lord, we'll take notice. Lordship can have it next Tuesday, my lord.
Counsel Arvind Chavan
Basically, Chinmaya only, but
accepts notice for the respondent. Relist the matter in the same stage on
18.
Yes.
28. Atul Krishna Rao.
Referring to the petitioner, my lord. My lord, this is with respect to the 26 AS. Based on the 26 AS, the service tax has been demanded.
Chinmaya trust.
Yes, my lord.
Counsel Arvind Chavan accepts notice for the respondents. List the matter in the same stage on
18.
18.
29.
Much obliged, my lord.
Sharon N.
No, but Arvind, after that last time we passed that order.
Please, man.
Why again, these are, after that, why should they again keep on repeating?
No, my lord, these are orders.
All those.
2023 orders, my lord. Now it is being challenged. There is
Now
a
they
delay.
don't, now they're not doing it in that fashion.
No, they are not doing it.
Yes.
After your lordship's order, my lord, maybe around 60 to 70%, there is a relief that has been provided, my lord.
Yes.
In some matters, officers, they commit the same mistake.
Yes.
29.
Lord, for petitioners, my lord, this is to consider my representation, my lord, which are annexure F, G, and H. Land has been acquired for formation of industrial area, but award was not passed. In that regard, my lord, I have made representations. It has not been considered, my lord.
Land Council, HL Pradeep Kumar accepts notice 1.2 and 3 AGA for first respondent list the matter in the preliminary hearing list on
16th, my lord.
16. Yes, next.
Grateful, my lord.
30, then 31. Lakshmi Menon. 31.
Lords, this is a case where, my lords, where the tax liability was paid, my lords, but in filing our annual return in GSTR4, the petitioner is a composition chosen for the composition scheme. So he has to file quarterly returns and an annual return at the end of the year, my lords. Lords, in the annual return, if my lordship goes to the order in original, page number 33, my lords. Para 2.2, my lords, at page number 33.
Yes.
During scrutiny of GST returns for FY 2021, it was noticed that the taxpayer has not declared the rate-wise details of outward supplies in Table 6 of GSTR4. As a result, the amount of tax paid through CMP-08 for said financial year has become excess paid and got credited to negative liability statement for adjustment of future tax liability, and the same is liable to be recovered with interest as per CGST Act. On perusal of CMP-08 quarterly returns filed by the taxpayer, it is observed that they have declared tax liability of 1,22,300 for financial year 2021. However, as per GSTR4 returns, they have declared outward tax liability as zero, which resulted in flowback of tax paid, inasmuch as the amount paid through CMP-08 for FY 2021 became excess tax paid and gets credited to the negative liability statement for adjustment of future tax liability. This has resulted in short payment of tax. Lords, the only thing is that we have paid tax. If I take my lords to GSTR4 at annexure F, my lords, page number 73. It starts at page number 72, my lords, where this is the annual return which I filed. At page number 73, my lords, in table number 6, at serial number 1, my outward supply, I have not mentioned my value. It's due to inadvertence that was not mentioned, my lords. And this is because of this value has not been mentioned, the amount which I had paid has not been adjusted against this. If my lord sees table number 5, the table just before, at page number 73 itself, it shows that the outward supplies is 29,77,000 and central tax and state tax 61,000 each has been paid, my lords. So, my lords, this is just due to this inadvertent mistake, my lords, and this coordinate bench of this honorable court, even in errors in GSTR1, has permitted us to rectify the said errors, my lords.
It is mandatory for them to reflect in the returns, my lord. They have not done so. If your lordship sees page 38, my lord, even after the show cause notice is issued, calling upon the SSC to explain, and at para 6 and para 7, in page 38, para 6 and your lordship see, multiple opportunities has been provided. If he had submitted the same before the adjudicating authority and explained the same, maybe he would not have suffered this order, my lord. The lordship may kindly remand the matter to the adjudicating authority because it's an ex parte order. Let him make the submissions on merits before the adjudicating authority.
Please, my lords.
So who's responsible?
My lords, what has happened is
Auditor.
Not auditor, my lord.
No, no.
Yes, your lordship rightly observed.
He didn't communicate to the petition.
My lords, what might happen in these cases, the auditor will be servicing a lot of clients, my lords. Unless they have a practice management software.
No, you pay him well now.
Please.
Pay him well. So simple. That is you try to cut corners.
Maybe assessee remembers auditors only at the filing of returns and
You pay
compliance.
him well. Now you're a lawyer, you have to look after well, isn't it?
Yes, sir.
The petitioner has sought for setting aside of the order in original at annexure A3. It is submitted that the order of adjudication page
Order of adjudication, page 31, order in original. Starts at page 30.
Order of
31.
adjudication
Internal page 38.
is an ex parte order, and petitioner has not made out reply to the show cause notice, nor availed opportunity of personal hearing. It is submitted that the authority has proceeded and adjudicated the matter without any reply of the petitioner. It is further submitted that the petitioner has sufficient material to demonstrate that the authority ought not to have passed order, and submits that there was mistake in the GSTR 4 insofar as outward supplies in column 6 was not enumerated despite similar entry being made in column 5.
Table, my lords.
In the table at column. Taking note of adverse consequences that visit the petitioner if the order in origin is allowed to remain, and noticing that the petitioner has asserted that lapse is on the part of his auditor. No, you have stated, is it auditor?
My lords, what has happened is.
No, so what is the reason given? I'm just.
The reason is, my lords, under contact details, a Naresh at elfins.in was mentioned. He was an employee of the consultant who has left.
And taking note that the employee of the consultant who was in charge of such affairs had left the company, and accordingly there was a lapse in making out reply. It would meet ends of justice by setting aside the order of adjudication at annexure
A3 and A4, my lord, summary of.
A3 and A4, and remanding the matter to the stage of reply to the show cause notice. All contentions of the petitioner are kept open. The petitioner to mark appearance before respondent number, before the respondent without further notice on. All contentions are kept open. What is the demand?
Lords, 1,21,000. Lords. Lords, we may be permitted to file a revised return and they may accept it, my lords. Because this honorable court has held that they might contend that only electronic filing is permissible. So this honorable court has held that even manually we can
Let that request be made before the adjudicating authority. Because if the time limit has elapsed or if online return has to be filed, my lord, then it will be in accordance with the section, my lord.
Now you make your request there, let's see. Yes.
Please.
32, Tanmay. 32, Tanmay Raj.
Yes.
This matter I'm challenging an order giving effect to the tribunal's order. Primarily on two grounds. One is that it is barred by limitation under 153(5).
150?
153(5), subsection 5. And also the assessment order that eventually came to be passed, my lords, has been manually signed, whereas the instruction of the department itself says where the proceedings have been conducted electronically, it will have to be digitally signed. So there are two grounds, two main grounds of challenge, my lords. The ITAT order is dated 15th June 2022, which my lords will see at Annexure E, page 190. In this order, my lords, there were transpricing adjustments under challenge, which the tribunal either held in my favor or sent them back for fresh adjudication to the TPO or the AO. Now, the end of the financial year in which this ITAT order was received would be 31st March of 2023. Now, under 153 subsection 5, there is 1 year time, 12 months from the end of the year in which the order is received, is the time limit to pass the order giving effect. So that, my lords, ends on 31st March 2024. All these orders are passed after this due date. The OG passed by the assessing officer, which finally culminated in the final assessment order, my lords, is dated 10th November 2025, which is at Annexure K.
Okay, let us.
Your Lordship, in the finance bill, my lord, we are amending this section, my lord, 153 by inserting 4B.
It will be prospective.
Yes, my lord.
It will be prospective.
Yes, my lord. No, retrospective, my lord. Act has not yet come, but to overcome the judgment of CIT versus Roka bathroom products, what has been relied upon by the
That
petitioner.
is one of the grounds I'm taking, my lords.
Let us see, let us see. You take complete your instruction.
Yes, my lord.
The petitioner submits that order is passed, order passed is beyond the period of permissible limitation provided under 153 subclause 5. Full stop. Submitted that the order of the ITAT was 15/6/22 and the order giving effect to ought to have been passed before 31/3/24. Full stop. However, full stop. Taking note of the contention raised and the passing of the order giving effect to on 10/12/25.
10/11/2025.
10/11/2025. There would be a stay of
All proceedings pursuant to that order, my lords, and the penalty proceedings, K and Q.
stay of annexure K and proceedings pursuant thereto, as well as annexure
Q, my lords.
Q. Full stop. One sentence. Petitioner has raised other contentions as well. Learned Counsel Sanmati accepts notice for the respondent.
Great.
Please, H.S. Suhas.
Yes.
I think your lordship's notice. On an earlier occasion, a petition filed by the same petitioner, your lordships have said not before me. I'm just bringing it to your lordship's notice.
Yes.
That's. I'm
Not
sorry.
before me.
Lords, may I make one request, please? There's some urgency in this matter. Let's just make.
To endeavor to list the matter before another bench on 20th.
Please. Deeply obliged.
Yes.
34. Ginit.
Your Lordship, this matter is regarding condonation of delay under section 119(2)(b). 119(2)(b). First time this is getting posted, so notice can be.
Take notice. Learned Counsel Ravi Raj accepts notice for the respondent.
One submission, Your Lordship. Identical matter is getting listed tomorrow of different assessment year. Can be, it can be listed tomorrow and can be heard.
Tomorrow is not the tax day.
Okay, then both can be listed on Tuesday.
Relist on Tuesday.
Much obliged.
Preliminary hearing list.
I
35.
I pay for the petitioner, my lords. This is a matter, my lords, on an acquisition wherein preliminary and final notification is passed, but award is not passed, my lords. Possession is also taken. I am not challenging the acquisition. My lords, it can be disposed of with, my only prayer is, my lords, they have to pass an award. let them seek instructions and produce if there is an award for my land or not. My lord.
AG accepts notice of first respondent, HL Pradeep Kumar for 2 and
Gopal.
3.
I'm for Gopal.
Gopal.
Yes.
Bilmane for 2 and 3. This is the matter in the preliminary hearing list on
23.
Meanwhile, if one clarification or a direction is given to produce the award in this land, it can be disposed of.
To verify and take a stand if award is passed.
In the subject property.
Yes.
Grateful.
36, Prashant.
My lords, a date may be fixed, my lords.
We've given a date.
Yes.
Great. 36, Prashant.
The challenge, your lordship, is to the order at annexure A. The interesting point, your lordship, healthcare services, your lordship, are exempted from GST. All healthcare services, your lordship. So provided you are on clinical establishment, etc. Now there is a definition, your lordship, of clinical establishment. This definition, your lordship, is an old definition from 2012, which they have borrowed in GST. And that's the clinical establishment definition, your lordship, that was there in the Clinical Establishments Act that is enacted by the center. And now, your lordship, that is borrowed by the states. Some of the states, your lordship, like for example, Karnataka has a Karnataka Private Establishments Act. Now, the petitioner in this case, your lordship, what he does is, traditionally, your lordship, as my lords recall, we have an ailment, we go to a doctor, the doctor attends to us, and then thereafter any reference is required, we go to a hospital, etc. Now that, your lordship, over a period of time has become so formalized. So we'll have to go to the hospital, get an appointment, wait for time, etc. Now what has happened, your lordship, is with the advancement of technology, there is no one app, your lordship, by which doctors are enrolled. So we as patients, we can opt for it, get to a consultation. The doctor on consultation, your lordship, will give us an advice whether it is possible, not possible, etc. Thereafter, he has to refer to a doctor, he will refer us to a doctor. There will be a set of hospitals that will be enrolled. So all that, your lordship, is getting done in a unified manner. So we petitioners have, your lordship, doctors on our rolls, then hospitals attached to us, so that we are a gateway, your lordship, for patients who want immediate attention through the use of technology. We say, your lordship, we are entitled for the same exemption of healthcare services. Because ultimately what we do, your lordship, is only healthcare services. We connect the doctors and the doctors provide the. They say, your lordship, that the actual doctors provide the healthcare service. We are only an intermediary, and therefore you are not to be considered as a healthcare service. We are precisely, your lordship, regulated by the Karnataka Medical Establishments Act, and there is a telemedicine regulations, your lordship, that came in 2020. So all of them, the doctors as well as us, are regulated by all this. Therefore, our submission, your lordship, is we are entitled to the same exemption that is available, your lordship, otherwise under a healthcare service. That, your lordship, is a short point. Just have a look at the notification for a minute, your lordship. Page 59, your lordship. At page 61. Your lordship. Serial number 74, your lordship. Down below on the right hand side. Services by way of healthcare services by a clinical establishment, an authorized medical practitioner or paramedics. And what, your lordship, is an healthcare service is also defined at page 65. Healthcare service. In fact, at page 64, my lords will see there is a definition of clinical establishment also. Page 64, down below, your lordship. Yes. Clinical establishment means a hospital, a nursing home, clinic, sanatorium, or any other institution by whatever name called that offers services or facilities requiring diagnosis or treatment or care for illness, injury, deformity, abnormality, or pregnancy in any recognized system of medicines in India, or a place established as an independent entity or part of an establishment to carry out diagnostic. So very wide, Your Lordship. So if ultimately the focus of the service is only healthcare service, then I would be considered as a clinical establishment. I would be entitled for the exemption. The order only says, Your Lordship, that you are acting as an intermediary, you provide a software service. That's only a medium. Otherwise, focus, Your Lordship, is on the healthcare service. That's a short point.
Now, what is the stage?
The order has been passed, Your Lordship, creating a demand of about 1 year, 18, 19, 30 lakhs or so, page 107, Your Lordship. And this is our business, Your Lordship. Practo's core business is only this.
That is it. It's like they're conducting it as a business, not as a service. All
hospitals, Your Lordship, also do it as a business. Page 107, Your Lordship.
Yes.
And more important, they have invoked 74 also, Your Lordship. Not a matter like this. Everything is declared, returns. We say we are entitled for exemption, they say we are not entitled. So you can't have a 74 demand for this. That's a short. This needs to be stated.
Why they invoke 74 is at page 106. This clearly makes an observation that there is a misstatement and suppression of turnover. Page 106, last portion.
Let us see.
Paragraph 1. Misclassification of taxable services as exempt constitutes willful misstatement and suppression of facts.
Let us see.
Then the notice has failed to disclose the true nature and supply of the returns, supply in the returns file. Section 74 is rightly invoked when tax is short paid due to wrong claim of exemption.
Now this is, there is no appeal.
There is an appeal, Your Lordship. There is an appeal. Our only point is this, Your Lordship.
Exemption.
Of challenge
Exemption.
Exemption. Pure exemption and 1 year.
Absence of challenge to any notification or principles of financial justice, all being absent. Detailed order has been passed, considering all the facts. It's certainly an appealable order under section 107.
Just one second only, Your Lordship. It is a interpretation of a notification, Your Lordship. 1. 2, a plain reading of the notification may suggest, Your Lordship, that actually the hospitals, etc., would be covered. But what has to be read into the notification, Your Lordship, is the advancement of technology that has happened. We are using this. And there are decisions, Your Lordship, of this court, where my lords have interfered to say that where advancement of technology has to be done, then my lords can interfere and take a view, Your Lordship. There are a few decisions we have placed it, and that's an old decisions also, Your Lordship. In my compilation, page 80, Your Lordship. The decision of 2003, this Justice R. Gururajan, page 80, Your Lordship.
Yes.
Same notification, 226.
Let us see. The petitioner.
I don't collect the tax, Your Lordship. Healthcare service, I don't collect the tax also from the patients.
Even on health insurance.
That's it. Now they have taken put off that. Today, all health insurance GST has been removed. All that has been done away. Today, these days, you don't have GST on health insurance also. That the government has, because it's more from an optics point of view.
The senior counsel appearing on behalf of the petitioners contend that the services being rendered by the petitioner are exempted in terms of the
Notification 12 of 17.
Notification 12 of
2017
at serial number
74.
It is submitted that the definition of services relating to healthcare requires to accommodate an expansive definition in light of advancement in technology, so as to include the nature of services being provided by the petitioners. Full stop. It is further submitted that such question of interpretation of the definition would be best left to this court and petitioner may not be able to raise such contention in the appeal proceedings. Matter requires consideration. In the interregnum, there would be stay of
Annexure A, Your Lordship.
A1 also.
annexure
A and A1, Your Lordship.
annexure A and
A1.
A1. Respondents.
Percent of tax amount will only amount to around 3 lakh.
No, our difficulty is this, Your Lordship. This is a common show cause notice that was issued for 5 years. It's about 70 crores or so. What they have done, Your Lordship, they are now passing individual orders because they want to get over my lord's rulings on consolidated show cause notice. This show cause notice is actually a consolidated show cause notice. Therefore, even on that, Your Lordship, the proceedings may not go on, may not stand because of the rulings of my lords.
There's no challenge to the show cause notice.
No, that's right. So therefore, Your Lordship,
This is a composite, is it?
the show cause, Your Lordship, was a composite.
Composite.
Now, what they do, Your Lordship, is in the light of my lords.
Orders have been passed.
Yes. Now, Your Lordship, they have started passing individual orders.
And my lords, in the prayers also, my lords, there is no prayer to pass the show cause notice on that ground. That stage is passed.
Now they're seeking for exemption. Either they get it or they suffer the entire.
Exactly.
Depends on the interpretation of a notification and whether the services that is rendered will fall within the meaning of medical services as defined in the notification. It's 10%, that is 3 lakhs is a very reasonable amount.
No, what? It's not a question of 3 lakhs in this.
President, that is what.
Correct. What these people will do is they'll shift that to the consumer of services.
We don't know whether it is already shifted.
No, it has not been done so far. That's I'm making a statement. It has not been collected so far because all along, Your Lordship, we have been claiming there are 5 services, Your Lordship. Pure software services, we are paying tax. That the order records. Pure software services, we are paying tax. These healthcare services, Your Lordship, because ultimately we collect it from the patients. And what we collect from the patients is what we.
Let us see.
I give it to
Yes. AG accepts notice for the respondents. Pleadings to be completed within 3 weeks. This is the first time, is it?
This, Your Lordship, there is only one. I mean, I don't know. My learned friend can say it. One other matter of HCG, Your Lordship, the cancer hospital. That, Your Lordship, has come before my lords. There, what happened slightly a different one is HCG and some other hospital enter into an arrangement. So the doctors from HCG will go to the other hospital.
That is a different.
So there, Your Lordship, again, healthcare services. We argued that ultimately what goes to the patient, whether from HCG or from the other hospital, everything is only a healthcare service. Therefore, the exemption should be waived. Your Lords have heard it. Justice Krishna Kumar has heard the matter, Your Lordship. Orders have to be passed. This, Your Lordship, to my knowledge, is the other matter that has come up on healthcare service.
Yes.
Grateful.
37.
Assessment years are indeed. Orders are passed, my lords, unconditional orders in unconditional stay orders in all matters.
Let us see.
Please.
37.
For the petitioner in this case. Lord, in this case, challenging the adjudication, divisional order passed by the second respondent. The hearing dispute is the tax period 2018 and 19. My lord, in this case, the petitioner is engaged in the activity of providing engineering services mainly to the government authorities by providing draft plans and allied ancillary services to the government authorities as well. That is for the year 2018-19, they have filed the returns by claiming the exemption that the nature of services whatsoever been provided by them to some extent is pure in nature by the virtue of notification annexed at Annexure G, my lord. Entry number 3, pure services, page number 76, man. 76. Pure services.
Now here you are providing services to whom?
Government authorities, madam.
Which one, to whom?
BWSSB and minor irrigation departments are the main government authorities. Subsequently, for the said period, the adjudication, there was an ex parte adjudication order. The ex parte adjudication order was challenged before the first appellate authority. Now the first appellate authority, while dealing the issue on hand in the appeal, in the similar,
Just one.
please. My lord, in the similar matters, my lord, 10% deposit is not being made.
No, no.
Coordinate bench of this.
Correct. They're only saying you already made the deposit.
Please, ma'am.
We'll see.
Please. Let there be an tomorrow.
Yes. The petitioner submits that they're exempted in terms of the notification of 12 of 2017 as the services rendered by the petitioner falls within the
entry number 3
category of pure services as enumerated in entry 3 of the said notification. Matter requires consideration. In the interregnum, there would be stay of
annexure F.
Order at annexure F.
Please.
F. Good stuff. AG accepts notice for the respondent. It's clarified that the deposit made while filing the first appeal is to remain and would be subject matter of final orders to be passed in the present petition. Pleadings to be completed within 3 weeks.
Okay.
38.
My lord, I'm for the petition, my lord. It is a cover by judgment, my lord. Actually, in 2004, BDA has allotted sites to the petitioners, my lord, and later on they have converted into a burial ground, where this honorable court has already passed an order stating to clear the burial ground.
Where is that?
In the page number 36, my lord.
Page?
36, my lord. Page number 36 and 42. There are 2 orders. My lord.
Now, who has reserved it for burial ground?
BDA has reserved it for burial ground.
You are in allotee, is it?
Yes, my lord. In 2024 on, 2004 we have been allotted, my lord. 2004 and 6.
Your Counsel K. Krishna is directed to accept notice for the respondents 4 and 5. AGA for 1, 2, 3. List the matter in the preliminary hearing list.
23.
But where will the dead go?
My lord?
Where will the dead go? There must be some place for the dead also.
Yes.
Huh? Yes.
39.
That's a place.
Alvin Rabbi.
So far as the vehicle, I think, has been released.
So this is a second appeal under 1 not?
Appeal against an order of connecting laws, they filed an appeal in the question 107, which has been disposed of.
Correct. So this is the second.
112 to the tribunal.
112.
But
Since the tribunal is not constituted, writs have to be entertained here.
The-
So far as stay is concerned, I think they've deposited the amount and got the vehicle.
no, we have not deposited the amount, your lordship. The goods, vehicles have been released based on furnishing of a bank guarantee, your lordship.
Let that remain.
But in my case, your lordship, I am challenging the very applicability of section 129 to the facts of the
Let us-
case.
let
And
us-
the issue is squarely covered by the decision of, of this coordinate bench of this honorable court, your lordship.
That I'll have to get into it because
Let us-
I also feel it's a minor mistake of wrong mentioning of a vehicle number in part B of EVP. Get instructions and then probably 3 weeks more.
The AGA accepts notice for the respondents. In light of the contentions raised and also noticing that the petitioner is entitled to file a second appeal under 112 of the Act, there would be a stay of operation of impugned order of demand and penalty at annexure B.
B and C, Your Lordship.
As
That
well as
culminated in C.
stay of the order in appeal at annexure C.
Please.
Yes.
that
AG
we are-
accepts notice for the respondents. Needless to state, the bank guarantee stated to have been executed while obtaining release of vehicle is to continue.
Please. Much.
Parte, Vachan,
Yes. Who appears?
Lord, we have served the notice, my lord. This issue is
Professional
simple, but
tax.
the,
Notice has to go in this matter
Huh?
because yesterday.
but it was moved in the, it was moved by my colleague in the morning.
Tax matter with the authorities are of Poonam. Notice has to be.
We have issued the email notice. The urgency is only this, my lord. The department is trying to seek recovery of the amount even prior to the expiry of the appeal period in respect of an assessment that is evidently barred by limitation. My legal right is arisen here. I have jurisdiction to move this court for the limited relief of preventing further precipitate steps in the matter. In the meantime, I'll go and file my appeal, statutory appeal in Maharashtra.
So the order is passed on.
My lord, order is passed on 2/2/26 in respect of a demand on 1/1/26. Assessment order and demand is 1/1/26. Recovery notice is 2/2/26. Under section 78 GST Act, my lord, I have 90 days.
78. This is one government department that is very efficient.
Lord, repeatedly, my lord, I have got so many citations issued, and then they don't seem to learn. Circulars have also been passed.
No, I'm saying this is one government department that is very efficient, I'm saying.
The sarcasm would be lost on them. 78, my lord, I was pointing out.
But all aspects of the tax bar, the tax advocates, the tax department, all are efficient.
That is true. We also need to be on our toes.
78.
78, my lord.
Yes.
Initiation of recovery proceedings. Any amount payable by a taxable person in pursuance of an order passed under this act shall be paid by such person within a period of 3 months from the date of service of such order, failing which recovery proceeding shall be initiated. The proviso, my lord. Provided that where the proper officer considers it expedient in the interest of revenue, he may, for reasons to be recorded in writing, require the taxable person to make such payment within such period less than.
So this is not there.
This is not there.
Where is the order?
My lord, order is at page 1717. The order itself says, my lord, demand order is of 1/1/26. The recovery notice is 2/2/26. Merely says make payment. He writes to my bankers saying make payment.
Where is the date of the order?
My lord, date of the order is on top, just above that form GST DRC 013, to the right side above that,
Yes,
at page 17.
2/2/26.
2/2/26.
That order you intend to challenge by way of appeal.
This order I intend to take, the demand order and the assessment I intend to take to challenge by way of appeal. In the meantime, the department could not have done this.
No. Yes. Huh?
But this is an issue arising out of Pune.
And my lord, as senior as put it, that there is an order, adjudication order. That officer had to be made a party here. And
He made a
we would
party.
have assigned reasons under section 7. If at all, my lord, if we have to cut down the period of 3 months, we have to cite the reasons for not,
Reducing it.
for reducing the time.
I'm grateful.
That proviso we use it, my lords, in cases where it is a fly-by-night operator or it is somebody whom will not be able to trace after 3 months or who might escape from paying the taxes. In such cases, my lords, we record the reasons and then issue him a notice saying that for this reasons
we are directing you to pay the amount within 30 days or within 15 days, failing which we will initiate recovery. That I will not be able to make out because the Pune authorities would have done it.
No, they are not. In fact, in the impugned order, they don't say so. In the impugned order, at least they don't say so. I'm a listed company.
In the impugned order. In
But
72
separately.
order, they don't say that.
There is no separate notice that I've received.
There is a stereotype computer generated sentence in the last that you have to pay this amount within 3 months. Then, my lords, a notice under section 78 is issued, citing reasons and cutting down the time.
We have said that there is no such reason assigned.
Let us see.
I think notice has to be issued both the respondent.
Issue notice to respondent 1 and 2. Senior counsel appearing for the petitioner submits that recovery proceedings are sought to be initiated in respect of an order of adjudication dated 1/1/26.
1/1/26.
1/1/26. He submitted that in terms of section 78 of the Act, petitioners entitled for payment of honoring of demand within 3 months from the date of order, failing which recovery proceedings are to follow. Full stop. He submitted that despite the said period not having lapsed, there is a demand that is raised as per annexure A. Full stop. It's further submitted even in terms of the proviso to section 78. The petitioner has not been put to notice as to whether the petitioner is required to pay within a reduced period of time. Full stop. Subject to further consideration, there would be a stay of
Recovery under pursuant to the notice.
stay of recovery till the lapse of the appeal period.
Lord, I would also seek refund of this amount because the amount has been blocked. For the time being, my lord, let this know till the next date of hearing. I'll serve and bring him here, or at least I'll notify him. Then I'll seek, my lord, release of this amount also.
Relist.
That I will do there. Account is not blocked, only the amount is blocked.
So relist.
Lord, release sometime next week. Next week sometime. My lord. Great.
41.
Petitioner in this case, madam. Challenge the adjudication order passed by the respondent. That is an ex parte order, my lord. A fair opportunity may be given to the petitioner, my lord. We will cooperate with the fine, my lord. Page number 27, my lord. Annexure D. And also in page number 28, my lord, paragraph number 6, my lord. In view of the non-submission of any objection, paragraph number 6, page number 28, my lord. In view of the non-submission of any objection, it was presumed that the taxable person has indirectly admitted the tax liability by not objecting to the aforementioned discrepancy note in so and so, my lord. A fair opportunity may be given to the petitioner, my lord. He will deposit the amount, my lord, before the authority. And also, my lord, at present they have blocked my all the bank accounts and issued notice to the one of my clients, my lord. The same is produced in Annexure E, page number 31. And also my client's amounts also blocked, my lord.
Yes, same Kumar.
Order is dated 25. No reasons have been assigned by them why it is not passed.
What is the reason why you didn't reply?
My lord, averments is, my lord, it's all bona fide errors, my lord. Though they have issued notice, have not received, my lord, but they are claiming through email they have sent the notice. All because of some bona fide errors, my lord. A fair opportunity may be given. I will appear before the authority, my lord.
No, but at least you should have mentioned in your pleading.
Yes, madam.
Have you stated anything?
The reasons I have not mentioned.
Correct. So
Yes,
you file an affidavit, we'll consider.
Please, my lord, I'll file my.
Hmm.
Maybe past hour, my lord, I'll, or else tomorrow, my lord, I'll.
Tomorrow.
Please, ma'am.
EJ accepts notice for the respondent. Release tomorrow.
But aware of
Huh?
kindly paragraph 10 at page 29.
Para?
Para 10 at page 29. In response to DRC 1 dated so and so, the taxpayer has tried to reply on. So refund requested 15 days time to file reply in detail. Then they will stop appearing. It's not that they were not aware of the proceedings.
Right. Now you just explain after keeping in mind para 10, some
Yes, ma'am.
reason after the first time what is the reason? We'll pass appropriate orders.
Please, ma'am.
Release tomorrow.
Please, man, I'll file my affidavit.
Release tomorrow.
Grateful.
42, appear for petition.
Motor vehicle tax matter not to seize the vehicle.
Yes.
Told. Similar matter, my lord, directed to list along with the connected matter WP 2045 of 26.
EGA accepts notice for the respondents. Same order. Relist on. What is the date?
Earlier 17-3. Some matters are 9-3.
Along with the matter. Along with
WP number 2045. Page 5. Order of my lord. 2045 of 26.
2045 of 26.
43, Hemant B.
Yes. Yes.
My lords, the present petition is filed we are challenging the immunity rejection order passed under section 270 AA of the Act, my lords. So the rejection order is passed on the ground, it is rejected on the ground that the immunity cannot be granted if the penalty is levied on underreported of income in consequence of misreporting, my lords. However, our contention is that it is not at all a case of underreporting of income, my lords. So we are entitled for a immunity under 270 AA of the Act, my lords. So
I'll take notice.
Learned Counsel YV Raviraj.
my lords, can it be listed to Tuesday, my lords, next Tuesday?
Notice for the respondent. No, no, they have to take the stand in writing now. It's an issue that requires consideration. Only after the pleadings are complete can we take it up. Whether it comes outside the ambit or not, they have to take the stand in writing. Pleadings to be completed within 3 weeks. This is the matter thereafter. Yes.
44.
2 weeks.
I have 1 of 26. I have just 1 minute. I have 1 of 21 minute. I have 1 of 26. Those documents are
for the
portal, is it?
Yes,
Downloaded
yes,
from the
yes,
portal. I1 of 26 is allowed. Petitioner dispense the production of certified copies of annexure A, A1 and A2. Taking note of the submission that the documents produced are printouts
yes, my lords, downloaded from the
downloaded from the portal.
Yes. Much.
44, Arjun Santosh.
Item 44, I appear for the plaintiff in this matter. So, commercial original suit. Parties have settled the matter. A compromise petition is also yes, ma'am. I had mentioned the matter yesterday.
Yes.
So, parties are present via VC, my lord.
I have appeared. I appear for the defendant, my lords, in this matter.
So, this is the judgment you said?
Judgment is of Karnataka High Court itself. It was passed through during the time of COVID, am passing the judgment, my lord. So the relevant para the issue in this matter was
Paragraph
your lordship, paragraph number 70.
17.
Yes, my lord. It was this page number 16 onwards, my lord. There is no legal impediment in the way of courts acting upon the compromise petition duly signed by parties which are presented by respective advocates. Though the parties are not personally present, the court may call upon the advocates present in the compromise petition to identify and attest the signature of their respective clients on the compromise petition. Apart from that, court may also call upon advocates' affidavits in some court duly affirmed by the parties in the suit. If the court is satisfied that the compromise is signed by the parties or the advocates duly authorized in sign and that the compromise is lawful, the court has a power to pass a decree in terms of the compromise in the suit without insisting the personal presence of the parties.
Correct. No, your friend is also not there.
Yes, my lord.
Your friend on the other side is also not present.
Other side is present through
My lords, I'm appearing for the defendant, my lords.
You're correct.
Yes, he's there.
No, at least the counsel should be present.
Counsel is present, my lord.
Where?
In the VC.
Appearing for the defendant, my lords.
Correct, but this says he has to attest it.
Yeah, either, but both of them are verified. Both the parties have filed the verifying affidavit also, my lord.
You may have to at least endorse, isn't it?
Yes.
Or file a memo to the effect. I'm not insisting on affidavit.
Okay.
At least a memo because he's your client who appears in VC.
Yes.
But then your friend is also not there. No
told
doubt
you.
I'll waive insofar as the parties
Their
are-
presence in the VC may be recorded, my lord, if that may permit.
Means where is the compromise?
Compromise, it mentions IA number 2, my lord. It was already filed in on record.
Page?
Yes, my lord.
Compromise at page?
Compromise petition, terms of compromise petition is mentioned in page number 3 of the running page number 3 of the IA, starting from para 8, my lord.
So what is the settlement now?
Settlement is they will not use our registered trademark MU and MUG for their products which are similar, and also they will not infringe or use our registered design for motor controllers, my lord. That, and also they would withdraw the design cancellation petition which they have filed to cancel our registered design, which they have already done, my lord. They have already complied their part of terms in the settlement at least to the extent of cancellation. There's a cancellation application. They are already there's already injunction against ex parte injunction against them, which is continuing as of date.
No, this settlement you have filed separately, isn't it?
Yes, my lord.
We have a different system of affidavit. We identify here
Yes,
Here,
my
when we file affidavits, where we do the notary in Karnataka, signature is identified by the council.
Yes, my lord.
But here, you don't follow that procedure, is it?
I think both the parties are aware out from outside Karnataka. My party was from Chennai and was currently based in Chennai, and the different company's director is from Gujarat. So hence that is the reason why affidavits are signed. My lord, one submission. There were similar matters also which were settled in this manner. Original suits which were transferred from trial court.
It's a different matter, sir.
Yeah, just I was submitted by lord.
Satisfy, isn't it? That's
Yeah,
all.
that
I'm
just
not-
made a submission, my lord.
No, that may be so. It's only a satisfaction of procedure.
Yes, my lord.
Now, who is present? You please mark their
I
appearance.
understand my client's authorized representative, Mr. Partha Mishra, who is the legal manager, is present via VC.
Now, you appear for the plaintiff.
I appear through plaintiff.
So the plaintiff is a company, is it?
It's a company. Both of them are company, my lord. Plaintiff is represented by the authorized signatory and the as deputy legal manager, Mr. Partha Mishra. Kindly permit. I think he's already logged in. And defendant is represented by Mr. Milborn.
Mr. Milborn, my lords. He's also logged in, my lords.
Partha Mishra is logged in. Mr. Milborn is also.
Shall I have it at 2:30? You just.
Yes, your lordship. If your lordship. Milborn is the different parties present, my lord.
Plaintiff.
Defendant is present.
Plaintiff.
Plaintiff.
2:30. You ask them to log in.
Yes, my lord. Actually.
Pass over.
Pleasure.
Both of you must file memos of identification. Pass over.
Obliged.
45. Nandakishore.
The matter concerning the peripheral ring road.
Yes.
My lords, I had a served copy to Mr. Murugesh. Interim order passed in the previous matter may be connected. 2466.
Counsel Murugesh Vicharati is directed to accept notice for the respondent 2 and 3 AGA for the first respondent. Petitioner submits that in the case of other landowners who have challenged validity of the acquisition proceedings, this court has passed orders protecting possession, and on parity, same orders may be passed in the present matter also. Order in WP 2466 of 2026 on 2226 reads as follows. Next, in light of the same, there will be a direction to the respondent BDA not to interfere with the possession of the petitioner. Such order is open for modification upon any further development at the instance of necessary application by respondent BDA. All contentions are kept open. Relist along with WP 8668 of 2014.
No, my lord, that has been parted, my lords. 2466 of 26.
2466. 2466 of 2026.
46.
What
are the office objections?
Look, issuing authority seal is not there, my lord. It may be overruled. I've produced as IA for dispensing with the certified copy.
IA for dispensation is allowed, subject to the petitioner furnishing complete copies in due course. What is this? What are these annexures?
My lord, the preliminary notification and the final notification.
Dispensed with Astisa.
Great.
46. Rakshita BJ.
Weeks of time may be granted for compliance.
Weeks time granted for compliance of office objections. Yes.
47. Hariher Prasad.
Huh? In week's time granted finally for compliance of office objections.
48, Manohar.
Same order. Next.
Please, my lords, the issue is very small, my lords. The office objection is regarding the prayer, my lords. I'm not pressing all the prayers, my lords. Lordships are issued notice on the last date of hearing, my lords. My lords, my appeals are pending. They are not deciding my appeal for more than 4 years, my lords. And with liberty of your lordships, in a writ petition, my lords, lordships granted me liberty to move a stay application. And my lords, subsequently, I have moved a stay application also. They are not deciding my stay application also, my lords. Lordships may kindly have, my lords, page number 55. The order dated 19/12/2024, passed in the writ petition number 27898, my lords.
Just 1 minute.
Please, my lords.
Office objections are kept in abeyance. AJ accepts notice for the respondents. You just find out, I'll have it on.
I'll find out, Lord. And the appellate authority has not been made a necessary party to the petition.
Appeal is pending, is it?
Please, my lord. Yes, my lord.
Then you have to make the appellate authority as a party.
Please, lordships may kindly grant me 2 weeks' time, my lords. I will do that.
No, let us see. Find out if it is only for.
I'll find out, my lords, because their prayer with regard to furnishing.
No, let us see. That's okay. That will see. No, now it's only on the disposal. Which year is being taken up now? I'll just record that and say according to chronology.
In fact, my lords, the first appellate authorities, they don't take much time. It's not going year-wise.
So just find out. Relist in AG accepts notice for respondent. Relist in same stage on 17.
Grateful, my lords.
49. 49.
2 days time we granted, my lord, for the compliance.
Weeks time granted for compliance of office objections.
List 1. Next matter, serial number 1. Ajay Kumar N.
My lords, this is a similar matter. Yesterday it has been disposed by honorable bench. So this is the case where subsequent to cancellation of GST registration, show cause notice and the orders were issued. Upon issuing the DRC 13, that is attachment to the bank account. So petitioner is aware of the fact that there is a demand. So upon aware of that, he proceeded to file a petition, my lord. So
what are the facts?
My lord, subsequent to cancellation of GST registration, show cause notice and orders were passed. And DRC 13, that is attachment to the bank account, that has been issued. So upon attachment only, that petitioner is aware of the fact that there is a demand order has been passed.
What happened? We disposed of, is it?
Yesterday, yes, my lord. I remanded back to the reply to show cause notice.
Similar order.
Similar. But in this case, there is an attachment to the bank. So that is additional.
Let me just get the draft. Friday. Relist the matter. AG accepts notice for respondent. Relist the matter in same stage on Friday.
Much.
Mark. A draft. Which is the other petition number?
3340. 3340.
Right,
3340 of 26.
I will write it.
Write it down and give it to the court of. That's it.
Number 2.
What's the APA for the petition?
Well, IA 1 of 26. IA 1 of 26 dispense ಮಾಡಿ. ಅದರಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ ಬರ್ದಿದ್ದಾರೆ. Downloaded from portal. Yes.
This is a matter which is challenging the show cause notice as well as the adjudication order issued under 74, please, my lords. My lords, on the grounds of that the show cause notice which has been issued, one such ground is that it could not have been issued because it is already disputing in settled matter. The petitioner My lords, was registered from 27 to 2020, please, my lords. 27 to 2020. Subsequently, at page 45, on 12/12/2023, one show cause notice came to be issued by the department, please, my lords, that is the same respondent, wherein page number 47 may be taken, my lords. For the financial year 2021-22, which is the similar my lords, financial year for the same for the present show cause notice and adjudication order. It stated that on the basis of a search and seizure conducted, second parameters, the taxable person produced the detailed books of accounts along with tax invoices, which is as under. On having gone through those, my lords, 7-8 materials which were, my lords, submitted by us, they came to the conclusion that there are 6 bogus inward suppliers from whom ITC has been availed by the taxpayer. It is in the same page, my lords. Subsequently, they listed about 31, my lords, genuine inward suppliers. Page 49, first para, please, my lords, may I read? Verification of the details produced by the taxable person is verified and observed that the taxable person made inward supply from the above dealers. Further verification of the details as per as 20 inward suppliers are in active remaining, 31 inward suppliers were suspended by the proper officers and other inward suppliers were cancelled suo motu by the proper officer. Further, the detailed Mahazar reports are the documents related to the bogus supplies made by the inward suppliers in support of his inward supply. The taxable person produced the original invoices of the invoice payment made through bank channels along with goods detailed through e-way bill is generated for the movement of goods. Therefore, the input tax credit from the above dealers is in accordance to the provisions of 16 clause 1 and 16(2) read with rule 36 and 37 of the KGST and CGST Act.
So they excluded these 31.
These 31 were excluded. I am interested, my lords, in serial number 14. Anam traders.
No, is in according to the.
Yes, it is in accordance to rules under 16(1) and 16(2).
So that means it's genuine.
It's genuine. Inward supply from these 31 are genuine. I am interested in, my lords, 14. Anam traders.
Yes.
Please. And they excluded this and they have raised a demand of, my lords, 87,66,025, which was paid by the taxpayer at page 53, may kindly be seen, my lords. And the proceedings were dropped. The summary is at page 53, the proceeding is at page 54.
Proceedings were dropped.
Proceedings were dropped. Subsequently, on having dropped these proceedings, my lords, Annexure E came to be issued in on 31/20/25. Again by the same respondent, that is same officer, another show cause notice in the year 2025 under 74.
Annexure
E, page 62. Claiming that the Assistant Commissioner of Commercial Taxes had previously, my lords, blocked my input tax credit under Rule 86A, stating that certain input tax credit which are obtained by me is wrongful, which was challenged by me before this honorable court and it was quashed. Basing on that, though it was quashed, my lords, this show cause notice came to be issued, stating that you have taken inward supply from Anam traders in the year 21-22 between 1/1/2022 to 28/3/2022. The list of invoices are from page 63 to 66. Anam trader has been, my lords, cancelled. Therefore, the input tax credit which you have availed of is wrongful, and hence you are a demand has been raised for the tax, interest, and penalty.
So this, according to you, is the Same, identical to.
Please, unarmed traders which were upheld to be, my lords, genuine inward suppliers.
Which period was that?
That was for the same period 21-22 by virtue of a show cause notice at page 45 in 2023.
Same period.
Same period. Same officer.
So now there's an order of adjudication afresh.
Please. Now, my lords, they gave me this show cause notice which could not have come. And subsequently, my lords, though it could, the grounds were that it could not have come, I participated by saying, my lords may kindly have page number 30 for a moment.
Page 30.
Please, 34. I replied on the show cause notice stating that according to you, that is according to the respondents, I have conducted my invoices for the transactions are between the period 1/1/2022 to 28/3/2022, and I copy pasted the my lords, their portal details of unarmed traders at page 34, which had stated that it is cancelled with effect from 1/10/2022. And my transactions are much prior to the cancellation. I brought it to their notice. Though I brought it to their notice, my lords, they have not considered this ground at all. And they only passed this order of DRC 07, that is adjudication order, on the basis that there existed a Rule 86A blockage of input tax credit by the Assistant Commissioner of Central Taxes. On that basis, I am passing this DRC 07. Just on that basis, without even adverting to the grounds which I have raised, they have done it.
Let us see.
No, so I'll accept notice. With regard to the 86A, that has got nothing to do with this. This Honorable Court, Malaj, has set aside the blocking of input tax credit on the ground that certain principles had to be followed before invoking Section 86A. That is what this Honorable Court has done. That is a different proceedings altogether. This is a different proceeding altogether. Maybe when the first order was passed in 2023, this unarmed traders, there might have been no reports, verification report or intelligence reports, which might have been subsequently received. It's not a case for grant of an interim order.
But his contention is that these, it relates to the same.
It might relate to the same period, Malaj. During that, maybe during that period, the input tax, what was the input tax credit that was blocked was stayed by this court. So probably that was left out. I don't know. I have to get instructions.
We'll have it on Tuesday. All these matters same, is it?
All three, please.
Now, what you have to verify, what he's saying, it was eventually dropped between that period. And same period, now you are seeking to reopen. But once you drop, then this, you find out.
We can reopen. Under 74, any number of times you can pass.
There's no bar.
There's no bar.
But the previous order, you say you have dropped it.
I'll
find out.
There are other grounds also apart from this.
That we'll see. No, this is only for interim prayer. I'll have it on Wednesday.
Please.
Otherwise, they have to have their pleadings to explain.
Please.
Certainly.
This.
The other grounds which I have raised is they have accepted that I am only entitled for penalty under 122. Though such being the case, they have made a demand for tax interest and penalty under 74. This is also one ground.
No, is there any interim order or no?
No interim order. They have attached my bank account. That is the urgency matters. Without, though there is a rectification application by me, without finalizing the rectification application, they have seized it.
Then we'll have the next. Let him find out. When do you want?
Wednesday.
AG accepts notice for the respondents. Relist on Wednesday in the same stage.
Please.
All same, is it?
2, 3, and 4 same.
2, 3, and 4 same order.
Please.
What is 5?
5, 17, and 18 are by the same petitioners against the central tax policeman.
5, 17, and
517 and 18, please, my lords.
Yes, what are these matters?
My lords, if I may pray my lords to take. My lords, 3436 for a moment, my lords, only for the sake of reference. 70.
Yes.
My lords, page 77. The petitioner, my lords, was subjected to audit for the period April 2018 to March 2023.
April
2018 to March 2023.
Yes.
By the Deputy Commissioner, please, my lords, respondent number 2. Wherein the Deputy Commissioner, my lords, initially made audit observation, called for my objections or hearing, and thereafter finalized the audit report, wherein page 78, 79 and 80 may be perused, wherein 11 observations were made.
Yes.
Of different my lords, revenue implications. These 11 observations in this audit report gave rise to, my lords, 3 show cause notices which are impugned in this order, in the 3 matters, please. With respect to the matter my lords are having, that is 3436, it is para number 10 and 11, that is the 10th and the 11th observation which was, my lords, gave rise to this show cause notice at page number 23. And some of them, my lords, were in 3605 and some of them were in 3608. All 11 were covered, please, my lords. Here the one initial ground of my lords, challenges, the show cause notice in all the 3 matters are, my lords, consolidated. It is for the year 2018 to 2023. On this ground alone, it may be set aside, apart from the other grounds which we have urged, please.
18 to 24.
23, please, lords.
Huh?
23.
18 to 23.
23, please. 18 to 23.
Common show cause notice, then I would only submit matters are pending. It is coming up on 18. Grant stay and keep the matter pending.
In light of the contention raised, that the single show cause notice relates to multiple tax period spanning between 2018 to 24, and taking note of observations made in Pramur homes and shelters, so and so, there would be stay of.
Let's annexure A.
Annexure?
Annexure A and B also. Annexure A series and B series, my lords.
A series and B series. Arun Chavan accepts notice for the respondents. Similar, is it?
Please, my lord, similar. 517 and 18.
517, 18, same orders.
Please.
Now they have to be linked or what?
It may not be linked, my lords. It may be called on the same day.
Yes. Refreshment is needed.
Lords, one humble submission. With the serial number 17 and IA number 1 of 2026 is pending. That is for the dispensation of production of certified copy.
It's from portal you have downloaded.
From the portal downloaded.
The 1 of 2026-17 is allowed in light of the submission that the copies produced are downloaded from the official portal. Yes.
Obliged.
Next to 2 preliminary matter, serial number 50, Hemant V. Dilip.
Yes.
My lords, in this matter, the revenue has filed objections and affidavit 2 days back, my lords. And senior advocate A. Shankar has been briefed in this matter and he is appearing, my lords. May it be taken on Tuesday, my lords. So we have to file lengthy rejoinder, my
There is
lords.
nothing new which has been given, my lord, other than what has been, I had filed submissions earlier on the first occasion, my lord. It's the same thing repeated, put it in a different format, that's all.
My lords, they have filed written objections, my lord. We also wish to file a written rejoinder. And since senior is not available, my lords, he's been briefed in the matter. This matter has wide ramifications as stated by the revenue themselves.
My lord, may I place my submissions, my lord, then they can.
Oh, my lord, we should be allowed an
Very,
opportunity.
my lord, very limited submissions.
Let them place whatever we'll hear on Tuesday. We'll see.
Second list.
List in second list on Tuesday.
Oblige, my lords.
You serve whatever you have to serve it in advance.
Yes, my lord.
51, Sudhindra S.A.
Respondent.
51, Sudhindra. K. Krishna.
Yes. We have a petition on this matter. Well, the BD has given an endorsement that is at annexure F. The total extent of the land is, my lords, it's 40 acres, 39 guntas. In that, only 10 acres is being acquired. Kindly take page number
No, his instructions.
116.
Instructions are complete. Yes. Annexure
F, my lords.
Page
116, my lords. In an endorsement, ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಮಂಗನಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ 40 ಎಕರೆ 39 ಗುಂಟೆ ಖರಾಬ್ ಜಮೀನು ಪೈಕಿ 10 ಎಕರೆ ಜಮೀನು ಪ್ರಾಧಿಕಾರವು ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ಭೂಸ್ವಾಧೀನಗೊಳ್ಳಲು ಪ್ರಾರಂಭಿಕ ಮತ್ತು ಅಂತಿಮ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ. ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ 18/2/2010 ರಂದು ಆಗಿದ್ದು ಭೂಸ್ವಾಧೀನ ಪ್ರಕರಣದ ಪ್ರಗತಿಯಲ್ಲಿದ್ದು ಹಾಗೂ ಇನ್ನುಳಿದ 30 ಎಕರೆ 39 ಗುಂಟೆ ಜಮೀನನ್ನು ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಿಂದ ಸೇರುವುದಿಲ್ಲವೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. And there is next page, my lords, there is a sketch. In that sketch, specifically I have stated, my lords, typed copy of the copy, my lords. ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ 40 ಎಕರೆ 39 ಗುಂಟೆ ಸರ್ಕಾರದ ಖರಾಬು ನಂಬರ್ ಆಗಿದ್ದು ಈ ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ ಸ್ಥಳದ ಪರಿಶೀಲಿಸಲಾಗಿ ಗುರುತಿಸಿಕೊಂಡು ಟೋಟಲ್ ಎಸ್ಟೇಟ್ ಯಂತ್ರದಿಂದ ಅಳತೆ ಮಾಡಲಾಗಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ 40 ಎಕರೆ 9 ಗುಂಟೆ ಬರುತ್ತದೆ. ನಂಬರ್ 2, ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ 10 ಗುಂಟೆ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆ ಪ್ರಾರಂಭಿಕ ಅಧಿಸೂಚನೆಯಾಗಿರುತ್ತದೆ. ಮೂರನೇದು, ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ 10 ಎಕರೆ 28 ಗುಂಟೆ ಮತ್ತು ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ 18 ಮೀಟರ್ ರಸ್ತೆ 10 ಎಕರೆ 28 ಗುಂಟೆ 2 ಎಕರೆ 18 ಗುಂಟೆ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 10 ಎಕರೆ 28 ಗುಂಟೆ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯನ್ನು ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಾಗಿ ಬೇಕಾಗಿರುವ ಪ್ರದೇಶ. ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವ 1 ಎಕರೆ 32 ಗುಂಟೆ ಅಧಿಕ ವಿದ್ಯುತ್ ಶಕ್ತಿ ಹೋಗುವ ಮಾರ್ಗವಾಗಿದ್ದು. ನಂಬರ್ 5, ಉಳಿದಿರುವ ಪ್ರದೇಶ 28 ಎಕರೆ 25 ಗುಂಟೆ ಬಡಾವಣೆಗೆ ರಚಿಸಿರುವ ಎಇ ಸೈಟ್ ಮತ್ತು RCC ಮನೆಗಳನ್ನು ಪೂರ್ತಿ ಕಟ್ಟಡದಿಂದ ಕೂಡಿರುತ್ತದೆ. So with respect to 28 acres, 25 guntas, these petitioners are residing there, my lords. In the sketch itself, they have stated they have only acquired 10 acres.
Let's find out the BDA. Yes.
My lord, it is the true, my lord, the 40 acres, 39 guntas land, we have acquired 10 acres, my lord, page 13 of the writ petition, kindly see the page 13 of the writ petition.
No, now it's 10 has been acquired. 10 acres acquired.
10 acres acquired.
They, in the para 13, the page 13, my lord, three, eight line from the top, my lord. They themselves admitted that the 8 lines from the top, the land where the petitioner's sites are situated are in the land which are not acquired by the BDA. Since the BDA has passed the resolution 98/15 to collect the Betterment Act charges from the revenue site holder, the petitioners have given representation individually requesting the BDA to consider their request. My lord,
My lords, the representations.
1 minute.
Just wait.
The represent they themselves says, my lord, it is not in the not unacquired area. My lord, the entire matter is pertaining to the Nada Prabhu Kempegowda layout. The division bench of this honorable court, my lord, said, my lord, the revenue citer, they have to make the application. If they, my lord, they
That correct. That will not apply if it's outside.
if it is outside, that if they let them to make the application, we afterwards, if it is outside the acquired area as committed contended by them, then they are not entitled for anything. If it is within they are entitled for sites, revenue sites as well. But here they themselves says, my lord, it is outside the area, and they have already constructed. The sketch now produced by the shown by the red print, it also says, my lord, where a constructed area is not acquired. So therefore, my lord, as per the, even in the page, my lord, kindly see para, page 32, my lord.
So now the endorsement stays.
There also said that we have acquired only 10 acres and remaining 30 acres are not acquired.
116 minutes.
So what are you challenging now?
Well, lords, now the BDA is trying to come and interfere with my position, and they are threatening us, and they are not allowing us to be in peaceful possession of the property by stating that it is being acquired. You are not supposed to construct anything. All these things. Well, let them give a clarity.
Okay, you take, put it in writing, that's all.
Yes.
Huh?
Yes.
Counsel K. Krishna submits that statement of objections will be taken insofar as the contents of the endorsement at annexure
F.
F list after 2 weeks.
It's until then, let them not precipitate the matter, lords.
Needless to state.
Yes,
respondent BDA they would not interfere with the possession of the petitioners in survey number 8. However, excluding portion of 10 acres stated to have been acquired.
Highly obliged.
Office objections to be complied with in the
it's complied. Only this typed copy of that annex sheriff, because there are 1,000 pages, so page numbers will be. It may be overall, my lords. Only that annex sheriff, which I annexure E, that handwritten script in that big map. That's the only objection.
Annexure G.
Yes, my lords.
Office objection serial number 1 is kept in abeyance.
Obliged.
Sir?
Yes, 27. ಕೇಳಿ. And the patient is there. So, okay. Yeah. Before the declaration. When is it?
ಸರ್ ಇವಾಗ ತಗೋತಾರಣ್ಣ
ಇದೆ. ಎರಡು ಇಟ್ಟಿದೆ ಸರ್. NS ವಿಶೇಷ. Home office of
My lords, item 27, list 1, after dictation, my lords.
Yes, I'll take it. How much time will take roughly?
My lords, in our estimate, about 40 minutes, and we'll be done because our argument is it's a covered matter. We just have to show it's covered. That's all.
My lords, kindly requesting for a listing in MPMLA matter, my lords, which is to come up tomorrow. We have sought for default bail. In fact, some of the co-accused filed a memo today, my lords. This is in the Koka matter which my lords had quashed. So this is the main offense which my lords had dismissed the petition filed by A5. So the co-accused is filing the petition for default bail. I request for the matter to be taken up tomorrow, my lords.
So, yes. The co-accused are seeking.
Accused number 1, default bail, my lords.
They're still in custody.
Still in custody since the last 140 days.
So what happened to the application before the trial court?
Please, it got dismissed. Then they filed a revision before the sessions court. There also it got dismissed. Now we have filed a 482 challenging that order. Please.
Mood matter, orders, Somsekhar Naidu B. Next to pass out matter, serial number 44, Arjun Santosh. Dedication, serial number 89, Saravana S. Saravana S.
The file code. Yes, Pradeep.
Tell Pradeep.
Dictating. KDB Act, KDB Act, KDB Act. The petitioner has filed the present petition seeking for issuance of writ in the nature of certiorari to quash the preliminary notification dated 7/8/2006 at Annexure D, as well as the final notification dated 5/9/2008 at Annexure E. Petitioner sought for a declaration that the notifications have lapsed insofar as it pertains to the scheduled property bearing number 7 to an extent of 4 acres. Perusal of the pleadings would reveal that the petitioners made out a case that B.R. Krishnappa, who was in possession of about 4 acres of land in survey number 7 of BK Palya village, Jala Hobli, Devnalli Taluk, was a grantee of land of the said aforesaid extent of land, and Sagoli Chit in that regard was issued on 12/7/1985. Full stop. It is further contended that name of said B.R. Krishnappa was not reflected in the revenue records, and the said Krishnappa died on 26/2/2002. Full stop. Next. It is stated that the petitioner, being the son of the said Krishnappa, had made representations for making entries in the, in inverted comma, computerized RTC. Next. It is stated that eventually proceedings were initiated before the Special Deputy Commissioner in LND CR 3 122/2008-9, and direction was passed by the Special Deputy Commissioner through orders dated 27/6/2011 to the Tahsildar to make entries in respect of the land. Next, it is submitted that pursuant thereto, mutation was effected in the name of the petitioner on 24/5/2013, and entries in the RTC have been made. Full stop. It is further averred that the petitioner was not aware of the acquisition proceedings. Next, it is submitted that it's only later petitioner, having come to know of the said proceedings, has sought to initiate appropriate proceedings before the authorities and this court. Next, Mele, one paragraph Mele. The petitioner submits that his possession was never disturbed, and it's for the first time revenue entries of the year 2020-21 make a reference to acquisition by KIADB. Accordingly, present petition has been filed. Petitioner submits that the proceedings for acquisition can be construed to have been lapsed as not having been completed, comma, that there is no possibility of formation of industrial layout in an isolated piece of property, comma, that in light of absence of entry of the name of the petitioner in the revenue records, petitioner has been deprived of an opportunity to participate in the acquisition proceedings. Next. Learned counsel, senior counsel appearing for the petitioners has raised certain other contentions. Including that insofar as Arab Binna Mangala is concerned, of survey number 1, KADB has extended the benefit of taking note of revenue entries affected in the name of landowners subsequently, and in fact has proceeded to amend the notification and grant compensation, and same benefit may be extended to the petitioners as well. Full stop. Learned counsel, senior counsel Shri Baswat Sabrad appearing for the respondent KIDB would rely on the synopsis with list of dates and submit that the preliminary notification was issued on 7/8/2006. Notification under notification under 28(4) was issued on 25/8/2008, on which date, that is the date of publishing of 28(4) notification in the Gazette on 26/9/2008, acquired land stood vested in the state free from all encumbrances. Next, it's further submitted that possession was taken on 22/11/2008, and accordingly the question of any proceedings under 136 to be initiated by the Deputy Commissioner after the notification under section 28(4) did not arise. Full stop. It's further asserted that the names of landowners in survey number 7 are found in the revenue records, and compensation as well has been dispersed to those persons whose names are found. Full stop. It is strenuously contended that the writ petition itself was filed only on 22/11/2022, which is which has with undue delay and latches, and at this point of time to interfere and grant any kind of relief to the petitioner would not be warranted. Full stop. Further submitted that the genuineness of the grant certificates of the petitioners is questionable, and reliance is placed
15/4
on the
15/4/25
on the order of this court
15/4 minutes.
of 15/4/25, and it is submitted that the exercise of verifying the genuineness having been made by this court in the proceedings, the stand of the revenue authorities is that there were interpolations in the Sagoli issue register,
And there is no entry in grant register.
and there was no information available in the original grant register pertaining to the grant stated to have been made in favor of the petitioners. Full stop. Next, it must be noticed at the outset that the petitioners claim to be grantees in survey number 7. No doubt, as pointed out by learned senior counsel appearing for KIDB, this court by order had directed the revenue authorities to take a stand regarding the genuineness of the grant. Full stop. Observations made in the order of 15/4/25 reads as follows. Next. In light of the same, there appears to be a prima facie doubt with respect to the grant stated to have been made in favor of the petitioner's father as asserted. Next. However, apart from such aspect, what requires to be noticed is that under the scheme of provision of the KIAD Act, which has been held to be a self-contained scheme, in contradistinction to the statutory scheme of acquisition under other legislations, in terms of section 28, the preliminary notification would be passed under 28(1) and published under 28(2).
Yes, ma'am. Lord, 28(1) is preliminary. 28(2) notice is Lord to the notified Khatada. 28(3) order Lord by the SLO. 28(4) is Lord the final notification.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ? ಅಲ್ಲ, under 28(1) full stop. Under 28(2) notice is issued on the owner or occupier to show cause why land should not be acquired, and then it is followed by an order by the government under 28(3). Next. Thereafter, once the state government is satisfied that land should be acquired for the purpose specified in the notification issued under subsection 1 of section 28, a declaration by notification in the official gazette shall be made to that effect. Full stop. The legal effect of a notification under 28(4) is that under section 28 subclause 5, on publication of the notification in the official gazette under 28(4), the land shall vest absolutely in the state, free from all encumbrances. Full stop. In the present case, in terms of the timeline, preliminary notification was made on 7/8/2006. The final notification was on 25/8/2008, published in the Gazette on 26/9/2008. Full stop. Is further asserted that possession was taken as per the procedure on 22/11/2008. Next, what is to be noticed is once the final notification, that is notification under 28(4) is passed, by virtue of 28(5), the land would vest with the state, free from all encumbrances. Full stop. Accordingly, as on 26/9/2008, which is the date on which the 28(4) notification was published in the official gazette, the land would vest in the state. Full stop. Such vesting is conclusive insofar as the question of possession is concerned. Full stop. Must be noticed that the petitioner's claim, if any, as on that date, remained inchoate insofar as there were no entries in the revenue records relating to their alleged grant. Full stop. The proceedings were initiated by the Special Deputy Commissioner under section 136(3) only in the year 2000, only on 27/7/2009. Full stop. This date would be of relevance since as on that date the 28 subclause 4 notification was already promulgated. If that were to be so, the order of the Deputy Commissioner thereafter, in exercise of power under section 136, could be stated to be one without jurisdiction, as no proceedings could have been initiated with respect to revenue entries after the date of vesting in the government. Next, what is of further relevance is that the writ petition by the petitioner itself is filed only in the year 2021, only on 21st November 2022. The relief claimed in the writ petition is barred by delay and laches. The say of the petitioner that they were waiting, that they have been in possession and were never disturbed, and were also waiting for revenue entries to be made, is a ground that cannot be taken note of as sufficient explanation for the delay. It must be noticed that the respondent KIDB has specifically asserted that in the interregnum, that is even before the writ petition was filed, a layout, industrial layout was formed. Which para that is?
Lord, objection statement, para number. Lord, para 6, Lord.
Which objection?
First objection, Lord. It was filed on 25/9/2023, my lords.
Para 6.
Para 6.
ಏನು ಬರ್ತಿದ್ದೀರಾ?
High-Tech Defense and Aerospace Park.
The respondent KIDB, in its statement of objections, had filed on 25/9/23 at para 6, has specifically stated that after acquisition, the board has formed a high-tech defense and aerospace park. Right. And plot numbers have been assigned.
Yes.
Next, it is the further case of the respondent KIDB, which would reveal that the names of the petitioners were neither found in the JMC nor reflected in the final notification. And in the absence of any revenue entries in their name, question of KIDB having considered the claim of the petitioners does not arise, and such contention requires acceptance. Full stop. The acquiring authority is required to look into the revenue entries which would be reflective of rights of persons interested, and there may not be any further obligation for the revenue authorities to make further inquiry at the time of notification. Full stop. It is also necessary to notice that the authorities have also produced records which would indicate that the JMC would indicate names of other persons as claimants and persons in possession in survey number 7. Full stop. When is this JMC prepared?
Lord, it is prepared on
2009.
9, my lords.
Huh?
9, my lords.
One sentence mail. The annexure R3 to the statement of objections.
R2, my lord, R2 and R3.
Huh?
R2 is, my lord, the report.
Huh.
R3 is, my lord, sketch, JMC sketch.
The
Date is, my lord, the lordship find.
annexure R2 is the JMC report and annexure R3 is the sketch filed along with the statement of objections by KIDB, which would
additional objections.
In the additional objections filed on 11 June 2024, which would indicate that planning was complete as well as the layout of sites way back on in the year 2009 itself. Full stop. Insofar as the disbursement of compensation, annexure R4 has been produced by the authorities along with this additional statement of objections filed. Full stop. Next, insofar as the contention of lapse raised in the pleading, though not addressed at the time of hearing of the matter, the respondent KDB have taken a specific stand in their statement of objections. At paragraph 7, at paragraph 7, it is stated the question of declaration of lapse would not arise in the present case, as the division bench in WA 604 of 2020 had observed that, had clarified that, where is that produced? Clarified that the question of lapse would not arise where final notification is issued. Full stop. You have a copy of that?
Lord, I don't have copy, but Lord, I have given Lord other judgments now, Lord, 2 judgments. That also it is, Lord, stated.
Which?
That is, Lord, ILR 2020 KR 4195. Srinivas Murthy and another.
Paragraph?
Paragraph number 29, Lord, that is says vesting. And before that, Lord, it says 24.2 that lapsing does not arise. Lord.
Para 20?
27, 28, 29. It says there is no time limit to prescribe in the KD Act for passing award. There's no lapsing.
Para 7 ಅಂತ ಅಷ್ಟೇ ಬರೀರಿ. ಅದಾದ್ಮೇಲೆ it's also to be noticed that reliance is placed by the respondent KIDB on the judgment of the division bench in ILR 2020 Karnataka 4195 in the case of K. Srinivas Murthy and another was the state of Karnataka, Department of Commerce and Industries and others. And para 27 would indicate that section 24(2) of the 2013 Act cannot be resorted to revive dead and stale claims and concluded cases. Full stop. The court had noticed that acquisition having been concluded in the year 2001 by issuance of notification under 28(4), a petition filed in 2016 could not have the effect of revival of the contention regarding lapse, as no time limit was prescribed under KID Act for passing the award. Full stop. What is the date of passing of the award here?
Lord, it was passed, my Lord, in the year 2000, my Lord, 10.
2010.
Date, my Lord.
In the present case, it is made out from the timeline that the preliminary notification was passed on 7/8/2006, final notification on 25/8/2008, possession taken thereafter, and award was concluded in the year 2010.
10.
Full stop. If that were to be so.
They are not concluded, my lord.
Huh?
They are not yet concluded. In para number 5, they mentioned only they released only 113 acres.
Lord,
Not
what
on the
happened,
181
Lord,
acres.
this 41 acres of land is, Lord, belongs to government. We deposited the entire amount to the government. Only for this amount. For the cultivable land, Lord, we have passed out. That is, Lord, different.
Survey
This
number
is
7 only
government
they have
land.
acquired only 113.
Thereafter, we got, Lord, back the money and we have released it to, Lord, as per the JMC to the persons who are interested as per annexure R4, Lord.
That's a consent award.
Consent award, 29-2 award.
Where is that dated? What is that dated?
That is, Lord, we have produced along with our objection statement, Lord, additional objection statement. Page number. Page, Lord, that is annexure R3, R4, Lords. Dated. R4.
No, those agreements you have produced.
Agreement for this, Lord, survey number 7 I have not produced, but Lord, for this also there are agreements and consent letters, Lord, given by Lord the persons who have received the compensation.
What is R4?
R4 is, Lord, the payment, Lord, register, Lord, signed by, Lord, the persons who have received the compensation.
Which year is this?
This is 2000 and 1912 2010, Lords. 1912 2010, Lord. The right hand side it is there, Lord. The date they have signed on, Lord.
Next.
1912. Next.
That you have to file a memo. What are the dates of that annexure? That
I'll just
that what you are saying, dispersal of compensation. You have to file a memo insofar as.
Please, my Lord, I'll file
R4.
along with, my Lord, the agreements.
R4.
R4 is, my Lord, the register. I'll file, my Lord, along with the memo. I'll file, my Lord, the agreements. Okay.
Next. It must be noticed that the petitioner's rights as on the date of final notification of 28/4 notification is inchoate. If that were to be so, the question of seeking lapse of the acquisition itself does not arise. Even otherwise, the petitioner's entries in the revenue records were made only much later, when technically the acquisition proceedings had reached a logical finality. Based on the limited pleadings made in the present petition, it would not be appropriate at this point of time, taking note of the period during which the JMC was prepared, as well as the sketch, to set aside the acquisition proceedings. The assertion by the petitioner that they were aware of the proceedings only later cannot have the effect of allowing a third party to intervene in the matter. In terms of R4, produced along with the statement of objections, KDB has relied upon dispersal of compensation to claimants. Even otherwise, we find that at this point of time, no case is made out to consider the case of a petitioner who, as on the date of the final notification, did not have revenue entries in their favor. Full stop. Further, this court had, by its order, directed the revenue officers to take a stand, and on 15/4/2025, there is a stand to the effect that there was no evidence of original grant itself. Accordingly, we find no grounds to intervene in this matter at this stage of time. Accordingly, ಇದರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಆಗಿದೆ ಯಾವುದು impleading it ಕೊಡು impleading. Now who appears for the impleading applicant?
Yes, my lord.
Huh?
We have filed the impleading application.
You have filed.
Yes, my lord.
To implead whom?
The parties who have taken the money, my lord. The award amount.
Lord, may pass on, Lord, the receipt, Lord, that is 2009, 25/9/2009, Lord. The receipt from Lord.
For the same.
Same.
Savita.
Savita. Service annexure R4. The last kindly take page number 17. Page 17. Lord, the photograph, Lord, you last can, Lord, see, Lord, the Savita.
Counsel, one paragraph. Counsel for the respondent. KIDB has filed a memo and enclosed copy of a receipt of one Savita who has accepted amount of compensation on the basis of consent price.
Please.
The said receipt is dated 13/10/2009.
9, correct.
15/10/2009.
9.
Amount of rupees 2 crore 48 lakhs has been accepted by the said person. Identity of the said person is seriously not in dispute, while noticing that IA under Order 1 Rule 10(2) has been filed to implead the said Savita. Accordingly, we find no reason to entertain claim made by a party who seeks to assert independent rights while noticing that the alleged grant had not been acted upon insofar as though the grant is stated to be of the year 87.
86.
No, 86.
86.
No revenue entries were made till order came to be passed under 136(3) by the DC only in the year 2011.
Lord, may pass, Lord, the agreements. These 2 crores 48 lakhs, Lord.
Correct.
2 crores 48. Same lady, my Lord, has executed, my Lord, agreement.
Ali receipt, adadmel one sentence. Copy of the agreement dated 15/10/2009 of acceptance of compensation and consent is also placed on record. Same is taken note of. You file a memo.
I'll just.
Accordingly, the petition is rejected. Yes. Impeding application is disposed of as not calling for adjudication. As at this point of time, the court cannot permit the present petition to transform itself into an adjudication of inter se dispute between the petitioner and those who had accepted compensation with respect to the same land in question.
Lord, serial number 54, which was connected yesterday, it was dealing, my Lord. This file maybe it kept along with that file, my Lord. After, my Lord, order is, my Lord, released, because, my Lord, there are certain documents which are relevant, my Lord, to adjudication of, my Lord, serial number 54, my Lord.
That you make a memo. I'll give a date for that sometime next week.
Next
week. That time you.
It can also be disposed of.
Summon this. Adinnon date.
54. Next week.
54 relist on.
For petitioners, my lord.
We'll relist it.
Interim order may kindly be extended.
Relist on 23rd. Interim order earlier grant is extended till the next date. Yes. So,
Obliged, my lord.
time.
230 matters. BC Venkatesh.
Okay, for petitioner.
It was the fifth response, my lord.
There is a matter, I was directed to produce the file. Yesterday, day before, I could not go. I was in arbitration. I get it, my lord, by Wednesday next week. I apologize.
When do you want it?
Wednesday, my lord.
In 18th.
18th or 19th, my lord, I'll get them.
Relist.
2:30, my lord.
At
Sorry.
2:30
Please.
on.
19th, 19th. I'll go there and I'll get that.
Huh?
I'll go and get that. I'll go to the office and get that.
No, correct. Huh? 20? 25th. Huh? 25th at 2:30.
Please. Great.
Interim order in operation is
Requested my
continued.
friends also, my lord.
Interim order the next day.
Interim order might be
Yes.
extended, please.
I appear for the appellant in this matter, Your Lordship. This matter is pertaining to an RCM where the
Yes,
respond-
who appears? M. Kumar.
Your Lordship.
We have not initiated any recovery proceedings as of now.
But,
What they are,
Your Lordship, on this, there is a covered by judgment of our.
No, that's not a question. Now, what is the urgency we want to see?
Your Lordship, at annexure F, Your Lordship, may I take to page number 136, Your Lordship. Annexure F.
Now, what are the facts? Ex parte order, is it?
No, Your Lordship, what has happened, the brief facts of this case is this much, Your Lordship. I am a real estate firm, Your Lordship. I've entered into joint development agreements and I have constructed 3 properties in total, Your Lordship. And I have also executed this sharing agreement and I have put them in possession and OC is acquired, Your Lordship. Later to that, the state central government, the state goods and service tax authorities find me saying that I am underpaid under section 73 subclause 4 of the Karnataka goods and service tax. And they say that I am liable to pay 1 crore 43 lakhs, Your Lordship. On the similar basis, Your Lordship, before our High Court, and another judgment has been held by the same conventional bench, Your Lordship. I'm passing on that judgment. Your Lordship, in this thing also, the facts and circumstances of this case is similar, Your Lordship, wherein the tax authorities have leveled.
No. Now, what is the urgency now? I'll fix a date. What is the urgency?
The urgency is that under at annexure F, Your Lordship, now they are saying that there is continental action for recovery proceedings, Your Lordship. If I don't deposit the amount within today, Your Lordship, at annexure F, at page number 136, Your Lordship. Lordship, may I read it?
Now, what is the judgment of the coordinate bench you're relying on?
The judgment of the coordinate bench in the similar circumstances, they have challenged the audit report and the commercial tax the notice, Your Lordship, where they have held that the joint development agreement, herein they have asked me to pay for the entire land ratio, Your Lordship. Therein the coordinate bench has held that.
Which paragraph? Which paragraph?
May I, Your Lordship? Your Lordship, please come to page number 40 of the judgment, Your Lordship, at paragraph number 8, page number 40, paragraph number 8. The aforesaid facts and circumstances are sufficient to come to the conclusion that the adjudicating order dated 28/12/23 passed by against the registered person, that is the developer MS Devi Shri project, pursuant to which the said person discharged the entire GST liability in relation to the entire property, including 30% share of the petitioner under the joint development agreement dated 6/2/2017, and consequently the question of there being double taxation, that is payment being made by the aforesaid MS Devi Shri projects and once again payment being demanded for the petitioner would not arise.
You paid 30%.
Your Lordship, I have paid the entire for my land ratio and the ratio which have been transferred. I have attached the GST challans for the same, Your Lordship. My GST challans have been annexed at annexure H, Your Lordship, that is starting from page number 151, annexure H1.
151,
Your Lordship. These are the GST challans, and at the end I have attached at annexure J at page number 166 the clash ledger, where in total I have paid around 67,50,179 rupees, Your Lordship. Annexure J, page number 167.
What is this M. Kumar?
basically, sorry, I sent the file to get it. These are all appealable orders.
But it has been covered by our.
Just wait.
Please, Your Lordship.
Just wait.
And with great respect to what my learned friend is recommending, this judgment is not at all applicable to the case of. I don't know how he is
Just-
submitting
just-
this thing and
just-
interfering when I want to tell something. This is a case, Malaj, where the developer had paid taxes for the entire turnover. That is his share as well as the share of the landowner. He had discharged the entire taxes. And we had proceeded on the landowner for recovery of taxes on 30% of what share he got. Then Malaj, they came up before the court and said, the builder has paid it for the entire amount. You either give us credit or you give us, ask him to give refund to that, we'll pay you too. That was a revenue neutral case where we have already got it. In fact, in that case, my friend Jeevan appeared for the petitioner. And that is entirely a different matter. This is a case where, Malaj, we have to get taxes from the landowner. How do we recover that? Now, probably an order of adjudication is passed on the developer of the land, saying that you pay taxes for the entire turnover. That I have not really gone through the 5 minutes because I think for instructions we don't have it. Basically, factual positions are involved, interpretation of the agreement is involved, appeal has to be filed against this order. First appeal is there, fact finding authority is there. Let them go file an appeal for the first appellate authority. There is no question of any opportunity not granted.
But on that interpretation, some matters are pending, I think. What, who has to pay what at what point of time?
Interpretation in the morning also one is regard to the interpretation of an entry, it is that then no. But this is a case where somebody has to give it. Either the developer has to pay it or the landowner has to pay it.
Otherwise, you look into it.
And then notice has to go because it meant the landowner is also a party to the petition. They have to come and answer.
No, he claims he has paid his share.
And yes, and now all that is issued is a notice saying that you pay because we have to issue that notice because of the time limit prescribed under section 78. So we issued the notice saying that you pay the amount, otherwise failing which will initiate recovery procedure. They can just write back to the officer saying that we have filed a writ petition in deputy so and so. Matter was listed today, notice has been ordered, it will come up on a particular date, keep quiet. I'll also instruct the officer not to initiate any recovery procedure.
Shall we say?
This judgment is totally.
No, let us see. Now, can we say no further, not to take coercive steps till the next day?
I orally instruct the officer.
Yes.
Your Lordship.
Just wait. So when do you want him, Kumar?
I have it on 24th March. I'll immediately call up and instruct the officer not to.
26. Your Lordship, on 27th, on 24th, I am not available till 26th, Your Lordship. Maybe on 27th, Your Lordship.
27th is not a tax day.
Otherwise, you want 24th. 24th.
But on 24th, I am not available till
23rd. Otherwise, later we'll give a later date.
Post 28th, any date, Your Lordship.
This is the matter in the week commencing from.
Yes. Your Lordship, the only request is let there be a stay of the annexure A and B, that is the audit reports at least till the time being, Your Lordship.
Let us see.
Because they have, that is through which.
M. Kumar says he'll instruct the officials not to take steps till the next date. On the next date, we'll consider passing an order by them, let them complete their pleadings. Yes.
Basically, it's an appealable order.
Let us see.
I want to interpret the joint development agreement, they have to go before the appeal.
Otherwise, we can have it on a shorter date. Preliminary instructions you take.
Please.
We'll just.
My lord, I have it on 18th.
Relist the matter on 18th in the same stage. On that day, we'll decide. Yes.
In the meantime, if the stay could be.
He has indicated there ends the matter. M. Kumar says he'll instruct the official. On 18th, we'll see what is to be done.
Please, Your Lordship.
May God have on me properly.
Not that way, Your Lordship.
God has on me that I'll communicate to the officer.
Your Lordship, no, that's not the thing, Your Lordship. What
Let us see on 18th. We'll see on 18th. Yes. Next.
I have no doubt on sir. The only thing is the pressure I'm getting from them, from the authorities on my client. That's the reason I was pressing on it.
No, the pressure of your client on you, not authorities on your client. Yes. We'll see. Let's see.
Much obliged.
Chopra, Sanmati.
It's separate kurte pad.
Ladies and
Yes.
first, these are a group of petitions, all challenging orders passed under section 195(2) of the Act.
Just one minute. Mic, just mic.
Thanks. Mike. Sir.
Yes.
But these are a group of writ petitions challenging orders passed under section 195(2) of the Act, whereby I have been directed to deduct tax at source at the rate of 10% on payments that I make to a company based in Singapore called Google Asia Pacific Private Limited.
Yes.
Well, Google has what is called an AdWords program, whereby consumers who want their advertisements to be displayed when any person conducts a search. So suppose today you look at hotels in Bangalore. I search for hotels in Bangalore. So either on the right hand side or right at the top, there will be ads of various hotels which will appear. And then if I click on that ad, then the hotel will have to pay Google a amount by way of advertisement charges. Now this program was initially run by Google Inc. across the globe. Google Inc. had given the rights to run this program in all countries of the world other than the Americas to Google Ireland Limited. Google Ireland had appointed me as a distributor, a reseller distributor of this AdWords program for the territory of India. Litigation had ensued, both in the case of Google Ireland and in my case, and ultimately the tribunal has passed an order that the amount which I pay is not chargeable to tax in the hands of Google Ireland, and therefore there was no obligation on me to deduct tax at source when I made payments to them to act as a distributor of the program. Subsequently, the right to distribute the AdWords program in the Asia Pacific region was given to Google Asia Pacific, which is a Singapore-based company. And I have been appointed as a distributor by the Singapore entity. My lords, earlier, when I was acting for Ireland, as a distributor for Ireland, I had not deducted tax at source. Subsequently, as my lord is aware, by the Finance Act 2016, an equalization levy was introduced for the first time. In terms of the equalization levy, if there was an online advertising service which was rendered, then a payment of 6% had to be deducted by way of equalization levy before remitting the amount to the person on whose website or on whose site this advertisement was released. So from 2016 onwards, I have been deducting equalization levy at the rate of 6% on all the payments that I make, either to Google Ireland or to Google Asia Pacific. So that was accepted, and in fact, intimations have been passed saying that the equalization levy has been validly collected. First, initially, once the equalization levy was introduced, there was a corresponding exemption given in the Income Tax Act that any amount which is subject to equalization levy will not be chargeable to income tax. And therefore, an exemption under Section 10, Clause 50 was introduced. There was, however, one exception to that, namely, that if the overseas entity had a permanent establishment in India, then there would be no levy of equalization levy, but there would be a levy of income tax. And this equalization levy was really imposed based on a recommendation made by a committee that was formed by the central government to go into taxation of these kind of transactions. Subsequently, the scope of initially when it came in, it was only with regard to advertisement. Subsequently, the scope was increased and it also dealt with online commerce platforms and online services. But that is a subsequent event which we are not concerned with. Now in 2020, there was a further amendment to the levy, both under the Finance Act 16 as well as under the Income Tax Act. And it was provided that if the amount is characterized as royalty, then there is no equalization levy. Correspondingly, the exemption in the section 1050 is not available to you. But I was of the belief that, having regard to the view which had been taken in the earlier years, this amount could not be characterized as royalty. And hence, I continued to deduct equalization levy and remit the money net of the equalization levy to Singapore. This has been accepted by the department. They have at no point of time said that the equalization levy has to be refunded to me or anything of that sort. In fact, an intimation has been made where they've accepted it, because I have to file an annual return. When I applied under 195(2) for this financial year for grant of an exemption, because in the past they had granted me exemption, but when I applied for an exemption in this financial year, this application has been rejected for two reasons. One, that a 195(2) application is not maintainable if you are seeking a nil withholding certificate. It is only available where you ask for a deduction on a proportionate basis. That is their first contention. And the second contention is that this amount is correctly characterized as royalty, and therefore you are required to deduct tax at source at the rate of 10%, and the exemption under section 10 clause 50 is not available. So what my lord has to consider is two things. One is whether my application was maintainable, and secondly, whether this amount was rightly characterized as royalty. Just one other factor which I must point out. In the initial years when the litigation had arisen, there was a series of judgments of this honorable court whereby it was held that payment for use of software has to be characterized as royalty, starting from Samsung, followed by Synopsys, then the AR rulings in Citrix, etc. Those rulings were relied upon by the department in the 201 proceedings, which were taken in my case, to hold that this amount has to be characterized as royalty. That view was upheld by the commissioner, thereafter upheld by the tribunal. Matter came to this court, sent back, and now the tribunal has finally decided in my favor. Because by the time the matter came back to the Supreme Court, to the tribunal from this court, The Supreme Court had delivered its judgment in engineering analysis and it disapproved of the decisions of this court in Samsung, Synopsys, etc. So basis that, the tribunal now has decided in my favor that the amount cannot be characterized as royalty. Because there is, in the definition of royalty, both under the Act as well as under the Double Taxation Avoidance Agreement, royalty is defined to be consideration for use of copyright, process, secret formula, know-how, etc. And there is one additional clause which is common in both the definition sections, namely a right to use commercial, industrial, and scientific equipment. Because in the initial proceedings which were taken under 201, the assessing officer had characterized this as royalty not only on the ground that it was payment for use of a copyright, payment for use of a process, payment for use of know-how, but also payment for use of equipment. The Commissioner Appeals in those proceedings had decided that this amount cannot be characterized as a payment for use of equipment. That finding of the Commissioner Appeals was not challenged by the revenue in further appeal to the tribunal, and that matter attained finality in those proceedings also. Now, in the present proceedings, he has once again said that this is to be characterized as a payment for use of equipment. But now coming to the first issue, namely, whether I can apply under section 195(2) for a nil withholding certificate. In fact, for the earlier financial years, where I had applied that because I was subject to the equalization levy, the exemption under section 1050 is available, the officer himself has given me a nil withholding certificate. That is not disputed. But this issue is no longer res integra. My Lord sitting singly, and my Lord's judgment has been affirmed by a division bench. In Flipkart's case has held that you can apply for a nil withholding even under section 195(2). My Lord will just see that judgment. Now let's just see the first item, page 1. Now, if my Lord just turns to page 4, after my Lord's index, the petitioner has called in question. Has my Lord got that? The validity of an order dated so-and-so passed by the first respondent at Annexure A, whereby the application for a nil TDS certificate has been rejected and the petitioner has been directed to deduct tax at source at the applicable rate. The conclusion arrived at is as follows, my Lords. Then, if my Lord, I can trouble you straight to go to page 7, para 32.
Just 1 minute. Page?
Page 7, para 32. In light of the above factual matrix, the following points arise for consideration. Whether the application of the petitioner dated 15 January 2020 filed under section 195(2) of the Act was not maintainable. It is the contention of the revenue that the application under 195(2) is maintainable only in the event of a composite payment, and that where a nil deduction certificate is sought for, recourse is to be made under section 197. It must be noted that the Deputy Commissioner of Income Tax, while passing the impugned order, has not dealt with such aspect and has rejected the application on its merits. In the present proceedings, wherein the petitioner has sought for setting aside of the impugned order, the submission is made by the revenue that section 195(2) would not have been invoked. If it were the stand that the application was not maintainable, the DCIT ought to have recorded such finding while rejecting the application. In the absence of any finding regarding the non-maintainability of the application, it is not open for the revenue to canvass such point in the proceedings instituted by the petitioner. The judicial review of the order of the DCIT cannot be enlarged by considering fresh contentions, which would have the effect of altering the impugned order by reading into its substantive aspects which are not considered by the DCIT. As rightly pointed out by the petitioner, such a contention as raised finds a cursory and fleeting mention in the statement of objections filed by the revenue and cannot be raised for the first time in the present proceedings. Even otherwise, the scope of section 197 being distinct from section 195(2), as section 197 would come into an operation on an application by the recipient of an income, which is not the factual scenario in the present case. Because then my lords have set out the relevant forms and applications, I can skip that. Then please see Romans 7 at page 9. This court in CIT International Taxation versus Bogus Lend Lease Industries Private Limited has reiterated this position in para 12, which is as follows. As is clear from subsection 2 of section 195 of the Act, if the person responsible for paying any amount chargeable under this Act or non-resident considers that the whole of such sum would not be income chargeable in the case of the recipient, he may make an application to the assessing officer to determine the appropriate portion of such sum so chargeable, and upon such determination, tax shall be deducted under subsection 1 only on that proportion of the sum which is so chargeable. However, if the assessing authority is of the view that no tax is chargeable, a certificate to that effect could be issued to the person responsible for making payment. Once a certificate is issued, the liability of the person responsible for paying under the aforesaid provision ceases, and without any deduction, he may make payment to the non-resident. In so far as section 197 is concerned, it provides for a similar application being made by the recipient of the income. On such an application being made under section 197(1), the assessing officer can give to him such certificate as may be appropriate. If such certificate states that no tax is deductible until such certificate is cancelled by the assessing officer, the person responsible for paying the income is under no obligation to deduct tax while making the payment. In fact, the language employed is shall. Therefore, it is mandatory in nature. What is the effect of such a certificate was the subject matter of interpretation. Accordingly, it is clear that 197 can be invoked by the recipient, and accordingly, the contention that the present application under 195(2) is not maintainable is liable to be rejected. Then, my lords, dealt with transmission, my lords. And then please see Roman 10. The object of section 195(2) and section 197 of the Act are in the nature of safeguards for the assessee and are to be invoked to avoid consequences of a finding eventually that the payer ought to have made a deduction after assessment, and in such a case it would be open to treat the assessee as an assessee in default in terms of 201 of the Act, leading to a prosecution being initiated under 276B against the payer and disallowance of expenses under section 40A(1)(a) of the Act. So this was one issue. And then please see my lord's finding on this at page 22. Sorry. I'm sorry, just 1 minute. So what my lord has held, what my lord has held is really in Romans 7 at page 9. Accordingly, it is clear that after extracting from bogus, it is clear that 197 can be invoked by the recipient, and accordingly the contention that the present application of 195(2) is not maintainable is liable to be rejected. And then if my lord will just see para 39, the operative part. Para 38 and para 39. In light of setting aside the impugned order, in the context of the legal position as noticed, the only order that can now be passed is of one granting nil tax deduction at source. Accordingly, in light of the above discussion, the impugned order at annexure A dated so and so is set aside, and respondent number 1 is directed to issue a certificate under section 195(2) of the Act to the effect of nil tax deduction at source as regards the petitioner's application dated 15 January 2020. So clearly, my lords, my application was maintainable.
Can you just, if you don't mind, read 197 and 195 too?
Yes, my lord. Because 195(2), my lord will find at page 1.1183.
Yes.
Any person responsible for paying to a non-resident, not being a company, or to a foreign company, any interest, not being interest referred to in section so and so.
Just 1 minute. Some amendment, is it? 195(2).
I was reading 195(1). The obligation to deduct is under 195(1).
Yes, yes.
So the obligation to deduct is if the income is chargeable to tax. Now just see, any person responsible for paying to a non-resident, not being a company, or to a foreign company, any interest not being so and so, or any other sum chargeable under the provisions of the Act, not being income chargeable under the salaries, shall at the time of credit of such income to the account of the payee, or at the time of payment thereof in cash, or by issue of a check or draft, or by any other mode, whichever is earlier, deduct income tax thereon at the rates in force. And then 195(2) says, where a person responsible for paying any sum chargeable under the Act other than salary to a non-resident considers that the whole of such sum would not be income chargeable in the case of the recipient, he may make an application in such form and manner as the assessing officer to determine in such manner as may be prescribed the appropriate portion of such sum so chargeable, and upon such determination tax shall be deducted under subsection 1 only in that proportion of the sum which is so chargeable. So the department's case is that only if you come to the conclusion that the amount is chargeable, but the whole amount is not chargeable. Well, suppose today, just take a case of an individual. I purchase a property from a non-resident. I have to pay him the full sale price. Now, the recipient is chargeable only on the capital gains. He is not chargeable on the sale price. So therefore, I have to now decide what is the cost which he will get as a deduction, what is the expenditure which will be allowed to him as a deduction. I don't want to take the risk. Suppose I take the cost, sale price is 1,000, I take the cost as 400 and I deduct tax on 600, and department says, no, the cost is not 400, 300. Therefore, one view is that you apply for a determination as to whether of what portion of 1,000 should I deduct. The other view is that this entire 1,000 is not chargeable. And I still want a determination because I don't want a proceeding against me in future that you did not deduct tax at source. And therefore, as a matter of abundant precaution, I go to him and say, according to me, for ABCD reasons, the 1,000 is not chargeable. And hence, the amount is not exigible to tax in India. There is no obligation to deduct tax at source. Even in those circumstances, my lords has held, and even the officer in my own case for the earlier year granted me nil withholding certificates. So now to say that your application is not maintainable does not lie in the mouth of the assessing officer. And then see 197. My lord will see 195 has to be made by the payer. 197 is made by the recipient.
So it's a tentative adjudication. Tentative adjudication that takes care of your apprehension that tomorrow prosecution.
I should not be held to be an assessee in default because my lord, if my lord has referred to prosecution, prosecution is not there. Really, there are three consequences flowing from a failure to deduct tax at source. First, the tax can be recovered from me as a payer. Secondly, I will be liable to interest under section 2011A. And thirdly, a penalty under section 271 capital C can be imposed. So these are the three possible adverse consequences that may follow if I don't deduct tax at source. In order to obviate that, I apply. If I am right in my contention it is not chargeable, then you will issue a certificate. If not, then that's the end of it. I'll deduct in accordance with what you say.
Yes.
Now please see 197, which is at page 1.1190. We'll just bear in mind one fact, that 195 only deals with payments made to non-residents. And therefore, there is a special provision made in 195(2) for a payer to make an application, and in 195(3) for the recipient to make an application.
Yes.
197 is a general provision which deals with most cases of deduction of tax at source under the Act, subject to rules made under subsection 2A, where in the case of any income of any person or sum payable to any person, income tax is required to be deducted at the time of credit, or as the case may be, at the time of payment, at the rates in force under the provisions of sections 192, 193, 194, 194A, 194C, 194D, 194G, 194H, 194I, 194J, 194K, L so and so, this goes on, and 195, the assessing officer is satisfied that the total income of the recipient justifies the deduction of income tax at any lower rate or rates, or no deduction of income tax, as the case may be, the assessing officer shall, on an application made by the assessee in this behalf, give to him such certificate as may be appropriate. Now, it's very often what happens is.
So please, once again, tell me the distinction between 195 and 197.
Right. Because 195 applies only when payments are made to non-residents. And the obligation to deduct tax at source is imposed only if the amount which is paid to them is chargeable to tax in India.
Yes.
197 applies to a case where the recipient of any amount which is subject to deduction of tax at source under most of the other sections dealing with TDS is of the view that his total income is such that. So take a case where a company is regularly making losses. The amount which it receives is liable for deduction of tax at source. Because I'm a courier company. All my payments, people have to deduct tax at source. I am suffering losses. Therefore, if tax is deducted, it impacts my cash flows. So I can make an application to the commission, to the assessing officer, that having regard to the fact that my total income is nil or has been assessed at a loss in the past, please issue a certificate in favor of A, B, C, D, E, F, G, H persons that when they make payments to me, they need not deduct tax at source. The officer, if he is satisfied with my submissions, can issue a certificate that for these reasons, please don't deduct tax at source. Or suppose the rate of tax is 10%. But because my overall tax rate is say 3%, I will still have to claim a 7% refund. Suppose my losses are there or my profitability is not sufficient. Suppose in my business, I make a profit which is less than, because today, if you have to deduct tax at source at 30%, or say 10%, let me put it, 10% on the gross amount. Tax is chargeable at 30% on the net income. So my profitability, say if it is 30%, then if tax is charged at 10%, it is okay. But if my profitability is 20%, then my tax liability on 20% is 6. And if you require me to deduct tax at source at 10, then really I have a negative cash flow of 4. If I had to pay advance tax, I would have paid only 6. So to alleviate all those difficulties, this provision is made.
So under 197, the recipient can ask.
Can ask. Because my lord will see, any person is required to deduct, as the case may, at the time of payment or rates and so. The assessing officer is satisfied the total income of the recipient justifies the deduction of income tax at any lower rate or rates, as the case may be. Officer shall, on an application made by the assessee in this behalf, give to him such certificate as may be appropriate. Where such certificate is given, the person responsible for paying the income shall, until the certificate is cancelled by the officer, deduct income tax at the rate specified in such certificate, or deduct income tax as the case may be. Or deduct no tax.
Now, 197 envisages both are in the country.
That's it. It no, it also covers 195. So even the recipient could be outside the country.
Yes.
Well, today, for example, today, I as the payer don't know what the recipient's profitability will be. So I will say, and I can't demonstrate what the profitability will be. So I will tell the person whom I pay that I will deduct at the rate specified. If you want me to deduct at a lower rate because your profitability is lower, you please apply and get a certificate. Because I can't prove your profitability. That is for something to you, for you to establish.
Yes.
He may not give me access to his returns for the past to show there were losses.
It's kind of a comfort.
Absolutely.
Comfort for the person who pays.
Absolutely. The whole object of these provisions was that you have a mandate to deduct tax at source. If you without applying, it is not that, suppose today I don't apply, then I run the risk of adverse consequences flowing against me if my estimate or my argument that the amount is not chargeable is found to be incorrect. Then I will be foisted with the consequences. But if I don't want to enter into that litigation, then I say I will apply.
But however, sometimes it is stated that this is tentative.
Right, my lords.
What is the meaning of that?
So that means that suppose today, in the hands of the recipient, you determine the profit percentage, say in our example at 20%. But ultimately, when you make an assessment on the recipient, you may come to the conclusion that his profit percentage is 40. The fact that you've determined that 20 does not preclude the department when assessing the recipient to make a proper assessment. That is why it is supposed to be a prima facie.
Yes.
And my lords, the whole point is this. Today, different considerations may apply where you pass an order under 195.2 or 197.1, because that is a prima facie determination. But when you pass an order under 201, that is not a prima facie determination. That is a final determination, because there the officer is suo moto assuming upon himself the jurisdiction to give a finding that the amount is chargeable in the hands of the recipient, and then recover the tax from the payer. So, Manoj, we are not concerned with that, but I just want to draw this distinction that the prima facie is at the stage of 195.2 or 197. 201 is a final determination, because quite often people seem to mix up between the two situations, and there is a difference. So therefore, my lords, then this matter of Flipkart went to the division bench. Division bench has dismissed their appeal. So with respect, my lords, really the first reason given by the assessing officer does not survive.
Can we just have a look at what he has stated?
In the division bench?
No, the assessing officer.
Assessing officer, yes, my lord. My lords, if my lord will just see the impugned order, it starts at page 97. Para 5 at page 98.
Page?
Page 98, para 5. Which 7093, my lords, have got?
2476.
No, just 7093, which is the first year.
27.1.
Before me, you have to start with the presumption lordship doesn't know. I'm not familiar with this. Yes.
Was paragraph 5.
Page?
Page 98. The impugned order starts at page 97.
$7090. Huh? ಇದು IA ಇದೆ. Yes, page.
Page 97, the order starts from. I'm on para 5 at page 98.
Yes.
Maintainability of the application under section 195(2) of the Act. Section 195(1) of the Act imposes an obligation on the person responsible for paying to a non-resident to deduct tax at source on the sum chargeable under the provisions of the Act. Further, section 195(2) of the Act enables the person responsible for paying any sum chargeable under this Act to a non-resident, considering that the whole of such sum would not be income chargeable in the case of the recipient, and hence to make an application to the assessing officer to seek to determine the appropriate proportion of such sum so chargeable. Undisputedly, the application is filed by the applicant under section 195(2) of the Act. The applicant is specifically contending that the applicant is not required to deduct tax at source as contemplated under section 195 of the Act, as the payment made to the non-resident is not a sum chargeable under the provisions of the Act. To attract section 195(2) of the Act, the person responsible for paying to the non-resident has to admit that the amount paid to the non-resident is chargeable under the provisions of this Act. In case the payer considers that the whole of such sum would not be chargeable as income, as in the case of the recipient, he can make an application to the assessing officer to ascertain the appropriate proportion of such chargeable out of the total payment to be made. Section 197 of the Act provides for or enables the assessing officer to issue a nil deduction certificate or a deduction of tax at source at any lower rates. Section 197 of the Act is made applicable even for an obligation to deduct tax at source under 195 of the Act. Section 195(2) of the Act and 197(1) of the Act have been specifically provided by the legislature for two different purposes. If at all nil deduction certificate can be sought by the applicant, it would be under section 197 of the Act. A similar legal position has been expressed by the Supreme Court in the case of transmission. At para 9 of the said judgment, the Supreme Court has clearly held that the scheme of tax deduction at source applies not only to the amounts paid which bears income character, but also to gross sums, the whole of which may not be income or profit of the recipient. The Supreme Court has concluded that when the entire sum is not chargeable to tax under the Act, the rights of the payer or the recipient are fully safeguarded under 195(2), 195(3), and 197 of the Act, and has held that an application for the determination by the assessing officer for an appropriate proportion is provided, and that would safeguard the interest of the payee recipient. Similarly, the Supreme Court in the case of GE India Technological Center Private Limited has clearly held that section 195(2) of the Act is based on the principle of proportionality. Similarly, the Jurisdictional High Court in the case of Bovis Lend-Lease Private Limited at para 13, while examining the interplay between 197(1) of the Act and 195(2) of the Act, has clearly held that 197 of the Act is for lower rate of deduction or nil deduction certificate, whereas 195(2) of the Act is to determine the appropriate proportion of the sum chargeable under 195(1) of the Act. In view of the above, the request made by the applicant for issue of a nil deduction certificate under 195(2) of the Act is not maintainable, and the application is liable to be rejected on the same ground. Now, my lords, his interpretation of Bovis Lend-Lease is contrary to the view that my lords took in Flipkart. Please see what my lords have extracted in Flipkart on bogus lend-lease. You got a copy of bogus? Now just see Romans 7 at page 9. We've got bovis also, but I'll just show you what my lords have extracted. This court in CIT International Taxation versus bovis lend-lease has reiterated this position at para 12, which is as follows. As is clear from subsection 2 of 195 of the Act, if the person responsible for paying any sum amount chargeable under this Act to a non-resident considers that the whole of such sum would not be income chargeable in the case of the recipient, he may make an application to the officer to determine the appropriate portion of such sum so chargeable, and upon such determination, tax shall be deducted under subsection 1 only on that proportion of the sum which is so chargeable. However, if the assessing authority is of the view that no tax is chargeable, a certificate to that effect could be issued to the person responsible for making payment. Now, how more categorical can it be? So the learned assessing officer's finding in para 5 that by virtue of bovis this application is not maintainable, and he relies upon para 13. If you go back again to his order, at page 99 para 5(4). Similarly, has my lord got that? Third line from the top of para 5.5 small Roman 4. Similarly, the jurisdictional high court in the case of bovis lend-lease private limited at para 13, while examining the interplay between 197 and 195(2), has clearly held that 197 is for a lower rate of deduction or nil deduction certificate, whereas 195(2) of the Act is to determine the appropriate portion of the sum chargeable. But that appropriate portion could also be nil.
Yes.
And para 13 is actually something else. The reference is obviously to para 12, my lords. Para 13 is that tentative, what my lords was of tentative. So therefore, my lords, this first objection doesn't survive. Now, my lords, one then goes to whether this amount represents income which is chargeable to tax. Now, according to the assessing officer, it is royalty both as per the Act and as per the treaty. The definition of royalty in the Act is to be found in explanation 2 to section 9(1) small Roman 6, which my lord starts at page 1.57.
1.5.
97. Whereas section 9 deems what incomes are deemed to accrue or arise in India. And a payment by way of royalty is deemed to accrue or arise in India if it is paid by the government, or it is paid by a resident, or it is paid by a non-resident under certain circumstances. We are not concerned with that. But what we have to see is the definition of royalty in explanation 2, which is at page 1.58.
Yes.
For the purposes of this clause, royalty means consideration, including any lump sum consideration, but excluding any consideration, which would be the income of the recipient, chargeable under the head capital gains for 1. The transfer of all any rights, including the granting of a license in respect of a patent, invention, model, design, secret formula or process or trademark or similar property, the imparting of any information concerning the working of, the use of, or of a patent, invention, model, design, secret formula or process or trademark or similar property, the use of any patent, invention, model, design, secret formula or process or trademark or similar property, the imparting of any information concerning technical, industrial, commercial or scientific knowledge, experience or skill, the use or the right to use any industrial, commercial or scientific equipment, but not including the amount referred to in section 44BB, the transfer of all or any rights, including the granting of a license in respect of a copyright, literary, artistic or scientific work, including films or videotapes for use in connection with television or tapes, for use in connection with radio broadcasting, or rendering of any services in connection with the activities referred to in subclauses 1 to 4, 4A and 5. So couched in very broad terms. Not only for use, but even transfer. So my lords, normally one understood royalty to mean a payment made for use of some intellectual property. But under the definition in the Act, even a payment made for transfer would fall within it. Or imparting any information would also fall. But the definition in the treaty is much narrower. Whereas the treaty definition, my lord will find it's page number 385 of the writ petition, my lord will say. My lords, go straight to page 390. Article 12 deals with royalties and fees for technical services. That's para 1 of Article 12 gives the right to Singapore to tax its residents. Now just see the wording of Article 12.1. Royalties and fees for technical services arising in a contracting state, that is India, and paid to a resident of the other contracting state, that is Singapore, may be taxed in the other state, that is Singapore. So para 1 gives a right to Singapore to tax its residents in respect of royalty which arises in India. Then para 2. However, such royalties and fees for technical services may also be taxed in the contracting state in which they arise, that is India, according to the laws of that contracting state, that is India, But if the recipient is the beneficial owner of the royalties or fees for technical services, the tax so charged shall not exceed 5%. So suppose today, in accordance with the domestic law, it is chargeable at 25%. By virtue of para 2, India can tax at a rate, maximum rate of 10%. If under domestic law it is chargeable at 5%, then 5 will apply. Then comes para 3, and this is what we are concerned with. The term royalties, as used in this article, means payments of any kind received as consideration for the use of or the right to use. So my lord will see, use of or for the right, not for transfer. Any copyright of a literary, artistic or scientific work, including cinematograph film or films or tapes used for radio or television broadcasting, any patent, any trademark, design or model, plan, secret formula or process, or for information concerning industrial, commercial or scientific experience, including gains derived from the alienation of any such right, property or information, any industrial, commercial or scientific equipment other than payments derived by an enterprise from activities described in para 4b or 4c of article 8. So my lord will see that there is a reference to industrial, commercial or scientific equipment, but there is no reference to similar property, as my lord finds in explanation 2 to section 917.
Now under this, under 3.
Right, my lord.
Well, 3, the license fee also would be
Royalty, undoubtedly. But a license fee to use that particular category of intellectual property right. Well, just consider this. Today, when I'm a distributor of a product or a service, I am not using the product or service. I am a mere distributor. It is the advertiser who will actually use it, if at all he uses it. In a broader context, my lord, which will arise in the case of Google Asia Pacific, is it a payment which it receives for the use by the advertiser, or is it a facility which I am providing to the advertiser? Well, just as today, Times of India will publish an ad in either of its newspapers or magazines that it publishes. So when Bennett Coleman publishes Times of India or publishes Filmfare in the old days, Illustrated Weekly, and they receive consideration for publication of that ad, what you are receiving is a consideration for providing a facility to the advertiser. That your ad will be published on page 1, bottom right hand corner, or on the center page, or whatever it is. Here, what is it that Google is receiving the consideration for? That the advertiser, when somebody keys in the search words hotels in Bangalore, what will pop up is, my lords, ITC Gardenia. And if he clicks on it, he will then have to pay. Otherwise, he doesn't even have to pay. So it is for providing a facility to the advertiser that your advertisement will be displayed. And I'll show you later on, my lords, how it works. But the point is this: it's not a payment made for use of any copyright, secret formula, process, equipment at all. And the distributor in no event uses it. So these are the two definitions which my lord will keep in mind when my laws will construe the terms of the agreement. Now please see the agreement, my lords. Page 119. Has my lord got it? The Google reseller agreement is entered into on 1st April 2016. The effective date by and between Google Asia Pacific Private Limited, Google, and the entity identified on the signature block below, reseller. Well, just see the operative part. I'll take my lords to the definitions as and when the need arises. But if at page 120, my lord sees clause 2. Google appoints the reseller.
Yes.
Google appoints the reseller as a non-exclusive authorized reseller for Google in the territory of advertising space made available by Google through the ads program to advertisers, as well as of any other ads program and services which the parties may agree upon in the future, which specific terms and conditions shall be contained in an exhibit to the agreement, all under and in accordance with the terms and conditions set forth in this agreement. The reseller shall conduct its business for its own account, in its own name, and not as an agent, employee, partner, or franchisee of Google in performing its obligations hereunder. Reseller shall only refer to itself as an authorized Google reseller of the ads program. The reseller may not solicit business from and shall not sell advertising space, even if unsolicited, to any entity that does not have a principal place of business within the territory. For the avoidance of doubt, an entity's principal place of business will be determined by the place of such entity's registration or incorporation as applicable. All inquiries made by such entity for sale of advertising space shall be referred to the designated Google contract within 3 business days of receipt by the reseller of such inquiry. So for example, my lords, if Citibank India branch wants to advertise by contracting with Google India, they can't do it. They have to go to US. Then the reseller agrees. Now this is my obligation.
Just so the designated Google contact is last 2.1 last sentence.
Yes, my lord.
All inquiries by any such entity
shall be referred to the designated Google contact within 3 business days. So my lords, I have to then tell Google that this cannot be done by me. So therefore, Citibank is interested in putting an ad, let US contact Citibank.
Yes.
Then 2.2. The reseller agrees to market, offer and sell advertising space to advertisers in the amounts and according to the terms set forth in Exhibit A. Reseller must sell to advertisers and liaise with qualified advertisers directly with the reseller's own sale force and customer infrastructure. Reseller shall perform its obligations hereunder in a professional manner consistent with reasonably applicable industry standards and in accordance with this agreement. Reseller will sell ads program in accordance with the training provided by Google. Failure to do so and unauthorized representations to advertisers will constitute a material breach of this agreement and shall be grounds for termination under 8.3. So I have a right to sell and my obligation is to market and sell advertising space under 2.1 and 2.2.
Why does it say non-exclusive authorized reseller?
So why it is this, my lords? I'll tell my lords why. Because there are some advertisers who want to contract directly with Google Asia Pacific. Suppose they want to make a payment in foreign currency. Because many advertisers have an EFC account. So they have foreign currency available to them. If they want to pay in foreign currency, I can only receive money in Indian rupees. So if they want to receive in foreign currency, they can go directly to Google Asia Pacific website and choose an option to pay in foreign currency. So it isn't that every Indian entity is bound to come to me.
Yes.
And initially, my lords, what happened was, before Google India came, there were certain other independent distributors also. But we are not concerned with that, because now really more than 95% will come through Google India. Then add sign up process, my lords, I can skip that. Then 2.6. Reseller shall provide after sales service to advertisers in accordance with the instructions, training and standards of Google and as provided in Exhibit A. So my obligations are, my obligation is to market and sell and to provide after sales service. Google's obligation is to appoint me as a reseller, and then please see Article 3, Google's obligations. Google agrees to provide advertising space through the ads program for resale by the reseller to the advertisers as set forth herein. Google agrees to train the reseller as set forth in Exhibit A. Except as provided in Exhibit A, this agreement shall constitute a non-exclusive relationship between Google and. So Google's obligation is to provide the advertisement space and to train me in terms of Exhibit A. Then billing payment, I can skip that. Now please see para 5, because the department relies upon this. Whereas it deals with brand features. Brand features is defined in Article 1.4. At page 119. Brand features means the trade names, trademarks, service marks, logos, trade dress and trade names, including all applications, registrations, common law rights in the foregoing together with the associated goodwill. Now please see Article 5. Google shall own all right, title and interest to its brand features, including all intellectual property rights therein. Google grants to reseller a non-exclusive royalty-free license during the term to display the Google brand features solely for the purpose of the reseller's marketing and sale of the ad programs under the terms and subject to the conditions set forth in this agreement. The reseller will submit all materials of any kind containing Google's brand features to Google's designated contact for written approval prior to the release to the public. Furthermore, the reseller agrees to adhere to Google's then current brand feature use guidelines and any content referenced or included therein, which may be found at the following URL, and to such other guidelines or restrictions provided by Google in writing to the reseller in connection herewith. Except as set forth in this agreement, the reseller acquires no right, title or interest in Google's brand features. All use by the reseller of Google's brand features, including any goodwill associated therewith, shall inure to the benefit of Google. The reseller shall not challenge or assist others in challenging the Google brand features or the registration thereof, nor shall the reseller attempt to register any brand features or domain names that are confusingly similar to Google's brand features. Reseller recognizes Google's reputation as a provider of high quality products and services and agrees to continue to maintain the same high standard of quality while performing its services under this agreement. Google is familiar with the current standards of quality of the services provided by the reseller. Google agrees that the current standards of quality of services must be the foregoing requirements. Now, this is a feature which you will find in all distribution agreements. Because today, I am appointed as a distributor of Remand fabrics. Outside my shop, I'll put a board with the Remand logo. I can only do it for the purpose of sale. When I buy the cloth from Remand, I'm not making a payment of royalty. The putting of the board outside only enables me that this product is identified, which I'm selling. And that aspect is now concluded by two judgments of Delhi High Court. Whereas my lord is familiar with the judgment in Formula One. Whereas where Formula One had granted certain rights to hold races to JP. And they also gave them the right to use the Formula One logo on the tickets that they printed, the brochure that they came out. And the question was whether any part of the race fee which was paid represented royalty. And it was held that no, because this is really not, I cannot commercially exploit that brand feature. I only do it for the purposes of carrying out my obligations to market the product.
But insofar as the use of the logo,
That also is not a, first of all, there is no consideration for that. No, as I say, to something which is more current, I buy Remand cloth. It has the logo of Remand on it. But I'm not making a payment for use of the Remand logo. I buy a shirt from Zodiac. It will have that insignia of Zodiac on it. But I'm not making a payment for that. I'm buying a branded product.
suppose
Today, a Maruti dealer, let's put it this way, look at it this way. I'm a dealer for Maruti cars. At my showroom, I'll have the Maruti logo all over. But when I buy the cars from Maruti, no part of that consideration can be attributed to the use by me of the Maruti logo.
suppose there's a manufacturer of cars, a certain company X, and that X company enters into an agreement with another manufacturer Y, who's a new entrant. X and Y have some agreement of exchange of technology, etc. Y is permitted to use the logo of X. Then what happens?
But there he's not purchased a product. He has got the know-how to manufacture and the product which he manufactures to brand it. So therefore he is using that brand because he's putting it on his own product.
Yes.
Therefore, you, my lord, will just go back to para 5. Second line, Google grants to reseller a non-exclusive and royalty-free license during the term to display Google brand features solely for the purpose of the reseller's marketing and sale of ads program. That is all that I can use the brand for. Nothing else.
Yes.
Then the next clause which the department relies upon is clause Article 6. Confidential information.
Just 1 minute. Yes.
Confidential information shall mean any intellectual property described in section 7 below and any other information disclosed by one party to the other pursuant to this agreement, which is written, graphical, machine readable, or in other tangible form, and is described or marked confidential, proprietary, or in some other manner to indicate its confidential nature, or if unmarked, information which would by its nature would reasonably be considered confidential. Confidential information also includes oral information disclosed in confidence pursuant to this agreement, which by its nature would reasonably be considered confidential. Confidential information includes information in any form that results from, is based or derived from confidential information. Each party and its employees shall treat as confidential all confidential information of the other party and shall not use such confidential information except as expressly set forth herein or otherwise authorized in writing, shall at all times during this agreement have in place procedures to prohibit unauthorized duplication, misuse or removal of the other party's confidential information, and shall not disclose such confidential information to any third party except as may be necessary and required in connection with the rights and obligations of such party under this agreement, and subject to confidentiality provisions no less restrictive than the provisions contained herein and as provided below. Without limiting the foregoing, each party shall use at least the same procedures and degree of care that it uses to prevent the disclosure of its own confidential information of like importance, to prevent unauthorized disclosure, but in no event less than due care. Reseller shall take reasonable measures to limit confidential information to those employees who need such information for service. Where is the question of saying that there is any intellectual property right granted by Google, Asia Pacific to the SSE? This is a common clause in all agreements that if any confidential information is parted between the two parties, they will keep it confidential. That's all. Suppose, my lords, I'm tendering for a Government of India contract. So I have an Indian agent. The US EPC contractor gives the Indian agent that these are my profit margins. So I can't go below this price. Now that agent can't share that information with the government. It is given to him to enable him in his marketing efforts. That's all.
So you're saying if it was commercially exploitable.
That's a different matter. There's no such, and there is no payment made for this confidential information. And this is reciprocal obligation.
Yes.
Then user data. Google owns all right, title and interest in and to all information and data, including the user data collected by Google relating to qualified advertisers in connection with the provision of the ads program. Reseller shall maintain all user data in accordance with local law and regulation applicable to such data and shall implement policies and procedures with respect to the user data that are at least as protective of the rights of advertisers as is provided in the Google privacy policy set forth at so and so, and all relevant policies implied therein. To the extent that the nature of resellers' obligations under this agreement require reseller to collect and or process personal data on Google's behalf, reseller shall comply with any national data protection laws, regulations, rule, regulator guidance which are applicable to the processing of personal data by the parties as envisaged by this agreement. So this is just that whatever data is collected by India will become the property of Google Asia Pacific. But that is the thing too, because today what my lord is considering is, I have received some consideration. that is Singapore. If it is to be my income, it is in consideration for something which I give a right to Google India to do. Because income is a recompense for a service that I render or property that I part with. It is a recompense for labor or capital.
No, but you just tell me on facts.
Yes, ma'am.
Who is the reseller here? Who are the
India.
party?
Who is the petitioner?
Google India.
Google India. My lord, it says for the person who signs at the bottom. This is a template agreement, my lords. So if you see, please see, if my lord goes back to page 119, this Google reseller agreement is entered into on 1st April 16 between Google Asia Pacific Private Limited and the entity identified in the signature block below, reseller. The entity identified on the signature block below is, my lord, at page 126.
Google Asia Pacific is permitting Google India,
As appointing Google India as his reseller.
the platform to make use of to put advertisements, etc.
Not to Google India. It is permitting Google India to resell its ad program.
Yes.
So a Hindustan Lever will enter into a contract with Google India that I want to advertise Lux. So if somebody searches for soaps, I want the Lux ad to pop up. Taj Hotels will contract with Google India. If somebody searches for hotels in India, it will pop up. Indigo will enter into a contract with Google India. If somebody searches for flights from Bangalore to Varanasi, my flight should pop up.
Yes.
There was a reference to Exhibit A. Please see Exhibit A at page 127.
Yes.
The initial term shall commence on the effective date and shall continue until that date is 12 months after the effective date. Reseller agrees to register and activate a minimum number of unique new qualified advertisers and to achieve certain revenue objectives as mutually agreed upon by the by the reseller and Google, the performance requirements. Performance will be measured based on actual revenues generated from qualified advertisers received by Google from the reseller through the 30th day of the month immediately following each of the 4 periods. Marketing activities. During the term of the agreement, in addition to such activities as may be commercially reasonable and necessary to achieve the performance requirements, reseller will complete certain marketing initiatives to be mutually agreed upon between the reseller and Google. Non-exclusively, this agreement constitutes a non-exclusive relationship, billing and payment. In consideration of purchase of the advertisement space as a non-exclusive authorized reseller under this agreement, the reseller shall pay Google an amount equal to the adjusted net revenue invoiced by the reseller from the qualified advertisers within the territory pursuant to this agreement. In the event the monthly total of the gross amount invoiced by the advertisers to advertisers by reseller is less than the minimum monthly purchase as defined in Article 5 below, the reseller shall remit a payment equal to the minimum monthly purchase amount. For the purposes of this section, Adjusted net revenue shall mean the gross amount invoiced by the reseller, net of freight, insurance, value added and similar duties, taxes, charges, all credits, discounts, amounts refunded to qualified advertisers, reseller remuneration to be determined from time to time based on mutually agreeable terms and conditions. Then at the end of each quarter, this is a payment clause, So there is a minimum. So suppose today you fix a minimum amount of 100,000. So I have to pay them 100,000. But today, if my revenues, which Google India bills to the advertisers, is say 500,000, then 500,000 less taxes, less the reseller's commission or discount, whatever you call it, or remuneration. Say, assuming it's fixed at 10%. So 500 minus 10%, 50. So 450 minus taxes, etc., which is 25. I have to pay over 425. But if in that calculation, the amount is less than 100,000, I have to pay 100,000.
Yes.
Then 4.4 says reseller shall bear the credit risk and absorb the expenses related to bad debt on sales to advertisers. 5 is a minimum monthly purchase. Reseller agrees to purchase from Google for sale in territory a minimum US dollars 25 million or local currency equivalent in advertising space per month. My lords, in the operative part where Google's obligations were, well, I saw there was an obligation to train. Training is dealt with in 7 of Exhibit 1. Google and the reseller acknowledge that the reseller will need training to be, and for what? Will need training to be able to effectively sell the ads program. And hence, Google agrees to train reseller, provided, however, that the timing and location of such training shall be determined by the Google and the reseller, and the format and content of such training shall be determined by Google and its sole discretion. Training shall include 2 sections: how to sell the ads program and ads program training for customer care and technical support. Each party shall pay its own employee expenses relating to the training. So the training is to enable the reseller to sell the product and to deal with customers' queries. And the territory is solely of India.
How much more time will require?
It takes some time.
We'll have it.
Because as my Lord says, it's something which is, it may, just to understand, because this is something which my Lord, I don't know whether my Lord is familiar with this kind of a contract.
I'm understanding. We'll have it on Tuesday.
My Lord, can I have my Lord's indulgence? Instead of next week, can it be 25th? Is it at all possible? It's a Wednesday.
Yes.
Or 18th also, I don't mind.
Yes, 18th.
18th, very well.
We list on 18th. At 2:30 on 18th. You have filed your synopsis, is it?
We haven't filed a synopsis, madam.
You can file one in advance.
Very well, we'll do that.
After you finish, we'll see. The arguments of learned senior counsel. She is also appearing on behalf of the petitioner. Remains inconclusive. Relisted at 2:30 on. Yes, what is your case? No, is there any interim order? No interim order. By the?
Filing of returns of medium to small scale entities. And secondly, I challenge the order. Delay of an audit report for the regular adjudication order has been passed. That is not a challenge. Still not brought on record. Central authority is not brought on record. Yeah, I seem to have made an application for amendment of the petition. That can be allowed. This matter is regularly heard. I have state authorities have no jurisdiction to. There are two issues. One is
Let us see. Let us see. Relist the matter on Tuesday in the preliminary hearing list. Tuesday in the preliminary hearing list.
My lord, if I may.
Serial number 85.
My lord, there
withdraw
is-
the petition.
Withdrawal.
Withdraw. Since the matter is settled in the civil court. 85. I informed to the council and KDB.
Counsel for petitioners filed a memo which reads as here under. In light of the same, petition is dismissed as withdrawn.
My lord, list 2, serial 86, there's an urgency, there's no interim order. My lord, a short date and top of the list.
Yes, you ask wherever interim orders are not granted.
Yes, my lord.
You make a request to the court officer, it will come up in the list. I will
Grateful.
instruct you.
Grateful, my lord.
Wherever matters have not reached, interim orders would stand extended.
Grateful.
Other dates, you please ask as per request.
Great.
My lord, if I may be permitted to make a submission.
2:30, nobody was there.
Milord's list one, serial number 13, Milord. From the last occasion, you had said it may be disposed of as there is no interim period. It may be taken upon Tuesday in list 2 fresh matters.
ಯಾವ್ದು interim order ಇಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಮೇಲ್
List
you make request to the court office.
You. Today. Court officer.
Court officer. ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸರ್ ಒಂದ್ ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಸರ್. 8 9 ಇಂಟ್ರಿ ಮಾಡಿದೆಯಲ್ಲ ಸರ್ ಸರ್ 7 ಇಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ ಸರ್. 8 9 ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 10 11 ಆಯ್ತು 12 list 1 12 13
So 13. There's no interim order. It may be taken upon 18th.
14 list 1.
List 2 fresh matters it may be taken. Yes.
14 urgency 17 15 15 16 ಆಗಿದೆ 17
Serial number
19 ಆಯ್ತು 20
Sir, 1 week. List 120.
21 list 1 21 22
Sir, list 120 or date, sir?
21 interim order is ಇದೆ 22 List 1 23.
Sir, list 1 20 date ಹೇಳಿಲ್ಲ sir.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ಸೆಕೆಂಡ್ ಅಂದ್ರೆ
Sir,
ಆ ವಾರದಲ್ಲಿ ಬರುತ್ತೆ.
Sir, list 1 serial 20 sir.
ಲಿಸ್ಟ್ 1 24th.
Sir,
Sir,
list 1
list 1
serial number
24 ಸರ್ 24 17th ಡೇಟ್ ಕೊಡಿ ಸರ್, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ.
17th ಆಯ್ತು.
Sir, list 1 serial 20 sir.
1 23
20 sir.
ಲಿಸ್ಟ್ 1 20.
ಹಾ sir.
ಹಾ
ಯಾವ ಡೇಟ್ ಬಂದಿದೆ sir?
ಲಿಸ್ಟ್ 1 28 18th.
18th. Okay, thanks.
ಲಿಸ್ಟ್ 1 21 22 17th ಬರುತ್ತೆ. 23 ಆಯ್ತು. 2nd of March. 24 25
24 ಅದೇ 17th ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ ಸರ್.
ಸರಿ.
ಲಿಸ್ಟ್ 1 24 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ.
ಆಯ್ತು. 25 26
ಸರ್ ಅಪ್ಲಿಕೆಂಟ್ ಗೆ ಸರ್ ಈ ಕಡೆ ಅಪ್ಲಿಕೆಂಟ್ ಗೆ
ಯಾವುದು 26 18th
ಸರ್ ಇಲ್ಲ
17th
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಹೌದು
ಸರ್ ಅದು ಇಂಪ್ರೂವ್ ಆರ್ಡರ್ ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡತಾರೆ 690 ಕ್ಲೋಸ್ ಇದೆ
I will not be able to argue that they please
ಆಯ್ತು ಸರ್ ಅದಕ್ಕೆ
17th
ಸರ್ 17th ಇರಲಿ ಸರ್
20th
Sir, serial number 72, sir.
29 this one 29 right first week of month 30 31
ಸರ್ ಸೇಲ್ ನಂಬರ್ 30 ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು. ಸೇಲ್ ನಂಬರ್ 30
ಆಯ್ತು. 31
ಸರ್ 2 ವೀಕ್ಸ್ ಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿ.
ಆಯ್ತು
ಸರ್ ಸೇಲ್ ನಂಬರ್ 30 2 ವೀಕ್ಸ್ ಗೆ
31 32 33
ಸರ್ ಸೇಲ್ ನಂಬರ್ 32 ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇಲ್ಲ, 2 ವೀಕ್ಸ್ ಗೆ ಇಲ್ಲ 32 ಅಲ್ಲಿ ಇಲ್ಲ, 30 ಅಲ್ಲಿ ಇದೆ.
ಮಾರ್ಚ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಬರುತ್ತೆ. ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಡೇಟ್ ಇಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಡೇಟ್ 52 ಲಿಸ್ಟ್ 2 52 17th ಜಾಸ್ತಿ 18th ಸರಿ ಆಯ್ತು. ಸರ್ ಹೇಳ್ತೀನಿ
ಸರ್ 31 ಟ್ಯೂಸ್ಡೇ ಸರ್.
55 ಲಿಸ್ಟ್ 2 55
Sir, 55. List 55 ಸೆಕೆಂಡ್ ಆಗ್ತಿದೆ ಸರ್. ಮಂಡೇ ಡೇಟ್ ಕೊಡ್ತೀರಾ?
24 2nd ಮಾರ್ಚ್ ಆ ವಾರದಲ್ಲಿ ಬರುತ್ತೆ. 57
ಸರ್ 57 ಸರ್ ಅದು ಡೆಮಾಲಿಷನ್ ಮ್ಯಾಟರ್ 57
6 ಅದನ್ನ ಪಾಸ್ ಓವರ್ ಆಗಿರೋದು ರಿಪೀಟ್ ಮಾಡಿ. 56 ಸೆಕೆಂಡ್ ಮಾಡಿ
ಸರ್
Serial number 56.
ಒಂದು ನಿಮಿಷ ಯಾವುದು 56 ಡೇಟ್ ಎಕ್ಸಾಕ್ಟ್ ಡೇಟ್ ಇಲ್ಲ. ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಂತ ಬರುತ್ತೆ. ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಇಲ್ಲ 25th
Sir, serial number
ಡೆಮಾಲಿಷನ್ ಮ್ಯಾಟರ್
ಡೆಮಾಲಿಷನ್
ನಾಳೆ ಏನಾದರೂ ಆಗುತ್ತೆ
ಶುಕ್ರವಾರ 13th
ಕೋರ್ಟ್ ಆಫ್ ಸೀರಿಯಲ್ ನಂಬರ್ 67 ಕವರ್ಡ್ ಮ್ಯಾಟರ್ 17th ಕೊಡ್ತೀರಾ?
ಒಂದು ನಿಮಿಷ 58 ಲಿಸ್ಟ್ 2 58
Sir, serial number 55 to
23
67 17th ಕೊಡ್ತೀರಾ?
59
I'm just taking the date.
23 60 61 ಇಲ್ಲ 18 ಎಲ್ಲಿಯೇ ಬರಲ್ಲ. ಎಲ್ಲಿಯೇ ಬಿಡುವಲ್ಲ 23rd ಇಲ್ಲ 23rd ಅವತ್ತೇ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ. ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ ಫಸ್ಟ್ ಹೌದು ಆಯ್ತು 23rd 62 ನಾಳೆಗ ಆಯ್ತು 63 ಆಗಸ್ಟ್ ಅಂತ 70 64 65 66
ಸರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಸಾಹೇಬ್ರು ಒಪ್ಪಿದ್ದಾರೆ ಶಾರ್ಟ್ ಡೇಟ್ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂತ
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕಲ್ಲ ಶಾರ್ಟ್ ಡೇಟ್ ಬೇಕಾದ್ರೆ
ಸರ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಸಾಹೇಬ್ರು ಒಪ್ಪಿದ್ದಾರೆ
ನಾನು ಬರೆಯಕ್ಕಾಗಲ್ಲ.
ಲಿಸ್ಟ್ ಟು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ 18th ಓಕೆ ಬಟ್ ಲಿಸ್ಟ್ ಟು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್
ಬರುತ್ತೆ.
ಆರ್ಡರ್ಸ್ ರೀಚ್ ಆಗೋದಿಲ್ಲ ಸರ್.
ಆರ್ಡರ್ಸ್ ಬರುತ್ತೆ
ಸರ್ ನಮ್ದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅದಕ್ಕೆ.
ಆಯ್ತು ಹೇಳ್ತೀನಿ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ 67 17th ಡೇಟ್ ಕೊಡ್ತೀರಾ ಅಂಡ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ ಸರ್. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 17/12/2025. 67 17th ಕೊಡ್ತೀರಾ?
17 68
ಹಾ 17th ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿದೆ. ಪ್ರಿಲಿಮಿನರಿ ಬಿ ಗ್ರೂಪ್ ಹಾಕ್ಬೋದು.
ಆಯ್ತು 70 ಇಲ್ಲಿ ಇಲ್ಲ 71 72
ಸರ್ 72 18th ಕೊಟ್ಬಿಡಿ ಸರ್. ಸರ್ 72 18th ಕೊಡಿ ಸರ್.
ನನಗೊತ್ತು 72
18th ಕೊಟ್ಬಿಡಿ ಸರ್.
ಎಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆಯಾ?
ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಸರ್. ಟ್ಯಾಕ್ಸ್ ಮಾಡಿ 18th. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ನೋಡ್ತೀನಿ ಚೆಕ್ ಮಾಡಿ. 74 ಪ್ರತಿಯೊಂದು ಚೆಕ್ ಮಾಡ್ತೀನಿ. 75 76 77 79 18th
Sir, serial number 55 list 2. Serial number 55.
80 16th ಇದೆ ಹೌದು 16th ಇದ್ರದಿಲ್ಲ 81 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ ಸರ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಸೆಕೆಂಡ್ ಆ ವಾರದಲ್ಲಿ ಬರಲಿ ಆಡ್ ಮಾಡೋದು ಇದು ಮಾತ್ರ ಮಾಡ್ಬೋದು 82
ಸರ್
ರೆಕೆಟಿಂಗ್ ಇದೆ ಯಾವತ್ತು ಸರ್ 23 ಅದು ಮುಂಚೆ ಇಲ್ಲ 83 ಎಂಟ್ರಿ ಮಾಡೋದು ಇದೆಯಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಅಲ್ಲೇ ಬರುತ್ತೆ ನೆಕ್ಸ್ಟ್ 24th ಅಲ್ಲ ರಿಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ ಸೆಕೆಂಡ್ ಆಫ್ ಮಾರ್ಚ್ ಇಲ್ಲ 84 ಅರ್ಜೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಬರುತ್ತೆ 86 ಅರ್ಜೆನ್ಸಿನಾ 24 87 88 ಹೌದಾ ಅರ್ಜೆನ್ಸಿ 18 ಆಯ್ತು ಚೆಕ್ ಮಾಡ್ಕೊತೀವಿ ಇನ್ಯಾವ್ದು ಹೇಳಿ ಸರ್ ಅಷ್ಟೇ ಒಂದೊಂದೇ
Sir, serial number 55.
12 and 13 18th ಹಾಕಿರ್ತೀವಿ 17 ಜಾಸ್ತಿ ಇದೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಇರೋದು ಆಯ್ತು ಬರ್ದಿದ್ದೀನಿ ಆಯ್ತು ಹೇಳ್ತೀನಿ ಲಿಸ್ಟ್ 1 ಎಂಟ್ರಿ ಮಾಡಲ್ ಇದೆ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಲಿಸ್ಟ್ 2 ಒಂದ್ ಸೆಕೆಂಡ್ 44 ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ನೀವು ಆವಾಗ 2:30 ಇದ್ದಿದ್ದು ಆಗ್ತಾ ಇತ್ತು ಸೈನ್ ಮಾಡೋದಕ್ಕೆ ಯಾರು ಮಾಡ್ತಾರೆ ಇಲ್ಲ ಮಾರ್ನಿಂಗ್ ಬರುತ್ತೆ ಬಿಫೋರ್ 10:30 ಬಂದು ನೀವು ಜಲ್ದಿ ಇದು ಮಾಡ್ಬೋದು 10:30 ಒಳಗಡೆ ಬರುತ್ತೆ 28 ಡಿಸ್ಪೋಸ್ ಮ್ಯಾಟರ್ಸ್ ಅದೇ ಗೊತ್ತಾಯ್ತು ಇದು ನಮ್ಮ ಮುಂದೆ ಬರಲ್ಲ ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ ನೀವು ಅಲ್ಲಿ ಮೆಮೊ ನಾನು ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಕರೆದಿಲ್ಲ ಲಿಸ್ಟ್
20 ತಾರೀಕು ಅಂದ್ರು 20ಕ್ಕೆ ಅಲ್ವಾ 20 ಯಾವತ್ತು ಇಲ್ಲ ಅಂದ್ರೆ
ಸರ್ ಲಿಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಏನಾಯ್ತು ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್?
Second is 57. 13th. Urgent ಬಂತು. 64 64 first list. First 64 ಇಲ್ಲ. First 64 second list. ಪ್ರಕಾಶ್ ಮೆಚ್ಚಲ್ಲ ನಾಳೆ ಬರುತ್ತೆ, ಬೆಳಿಗ್ಗೆನೆ ಬರುತ್ತೆ, ಬಿಫೋರ್ 10:30 ಬಂದ್ರೆ ಆಗುತ್ತೆ. ನೀವು ಬೆಳಿಗ್ಗೆ ಬರುತ್ತೆ 10:30 ಒಳಗಡೆ ಬರುತ್ತೆ, ಬಿಫೋರ್ 11:30 ಬರ್ಬೋದು ರೆಡಿ ಆಗಿ. ಇನ್ನೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಯಾವತ್ತು ಹೇಳಿ, ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ, ಯಾವುದು ಲಿಸ್ಟ್? ಒಂದ್ ಸೆಕೆಂಡ್ ನೋಡಿ. APIM 12/25 20ನೇ ತಾರೀಕಿಗೆ ಮಾಡಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲ, ಆಯ್ತು ಬರುತ್ತೆ ಬಿಟ್ಟು. ನಾನು ಲಿಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಮಾಡೋದು. ನಾನು ಹೆಂಗೆ ಮಾಡಲಿ, ನಾನು ಇದು ಒಬ್ಬ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಒಂದೇ ಬರ್ಕೊಳಕ್ಕಾಗಲ್ಲ. ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ, ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಮುಂದೆ ಅಂದ್ರೆ ಯಾವ್ದು 24th ಹಿಂದೆ ಇಲ್ಲ, ಮುಂದೆ ಬೇಕಾದ್ರೆ ಅದು ಯಾವ ಲಿಸ್ಟ್ ಬರುತ್ತೆ ನನಗೂ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ ಲಿಸ್ಟ್ ನಾನು ಮಾಡಕ್ಕಲ್ಲ, ಫೈಲ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ಅವ್ರು ಮಾಡ್ತಾರೆ. ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದು 26th ಮ್ಯಾಟ್ರ್ ಡೇಟ್. ಇದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ, ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡಲ್ಲ. ವೀಕ್ ಕಮಿಂಗ್ ಸೆಕೆಂಡ್.
We don't have entry module.
ಡೇಟ್
ಸರ್ ಲಿಸ್ಟ್ ಒನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30.
ಏನ್ ಮಾಡ್ತೀರ ಅಂತಂದ್ರೆ, ಅವತ್ತು ಮೂವ್ ಮಾಡಿ ಆ ವಾರದಲ್ಲಿ ಬಂದು ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಅದು ವಾರದಲ್ಲಿ ಬನ್ನಿ. ನಿಮ್ಗೆ ಯಾವ ಡೇಟ್ ಬೇಕೋ ಆ ಡೇಟ್, ಯಾವ ಡೇಟ್ ಬೇಕು ಆ ವಾರದಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲ ಆ ವಾರದಲ್ಲಿ ನಿಮ್ಗೂ ಅದನ್ನ ಮೂವ್ ಮಾಡಿದ್ರೆ ನಾವು ಅದನ್ನ ಕೊಡ್ತೀವಿ. ಅದೇ ಸೆಕೆಂಡ್ ಆಫ್ ಮತ್ತೆ ಆ ವಾರದಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಇಲ್ಲ, ಅದು ಯಾವುದು ಅಲ್ಲಿ ಎಲ್ಲಿ ಮಾಡಿಕೊಟ್ಟಿಲ್ಲ ಯಾರಿಗೂ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್?
ಸೆಕೆಂಡ್ ಆಫ್ ಮಾಡ್ಕೊಡ್ತೀವಿ. ನಿಮ್ದು ಯಾವ್ದು ಬಂದು ಯಾವ್ದು ನಿಮ್ದು ಹೇಳಿ ಮ್ಯಾಮ್? 83ನಾ? ಸರಿ, ಯಾವ ಡೇಟ್ ಬೇಕು ಹೇಳಿ ನಿಮ್ಗೆ ಮಾರ್ಕ್ಸಲ್ಲಿ? ಒಬ್ಬರು ಕೊಟ್ಮೇಲೆ ಅವ್ರು ಕೊಡ್ಬೇಕು. 83 ಹಾಂ ಆಯ್ತು. ಲಿಸ್ಟ್ 156 23 ತನ್ಮಯ್ ರಾಜ್ಕುಮಾರ್ 33. ಒಂದು ನಿಮಿಷ ಆಗ್ಬೋದು. 56 25th ಆಫ್
ಸರ್ ಲಿಸ್ಟ್ ಒನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೊಡ್ತೀರಾ ಒಂದು?
ಲಿಸ್ಟ್ 2 ಫಸ್ಟ್ ಮಾಡಿ 59 23rd ಅದಕ್ಕೆ ಮುಂಚೆ ಲಿಸ್ಟ್ 1 19 ಎಂಟ್ರಿ ಮಾಡೋ ಡೇಟ್ ಇಲ್ಲ. ನಾಳೆಗೆಲ್ಲ ಬರುತ್ತೆ ರಿಪೀಟ್ ಮಾಡಬೇಕು. ಸೆಕೆಂಡ್ ವೀಕ್ ಮಾಡ್ತಾರೆ. ನಾಳೆ ಮಾಡ್ತಾರೆ.
Court officer, sir. Sir, list one serial number 30.
ಸಾಕಾಗ್ಬಿಡ್ತು. ಲಿಸ್ಟ್ 2 ನಾನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದನ್ನ. ನಾನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅದನ್ನ. ಬ್ರಾಂಚ್ ಕಳಿಸಿ ಅಲ್ಲಿ. ಮುಂದೇನೂ ಇಲ್ಲ ಸರ್. ವಿ ಸಿ ಮೇಡಮ್ ಹೇಳಿ. ಮೇಡಮ್ ಹೇಳಿ ಯಾವ್ದು ಮ್ಯಾಟ್ರು ವಿ ಸಿ?
Sir, court officer, sir. ಹಾ madam.
ಒಬ್ಬೊಬ್ಬರೇ ಹೇಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಲಿಸ್ಟ್ 2 ಮ್ಯಾಟರ್ ಸೆಟಲ್ ಆಗ್ತಿದೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 2.
ಶ್ರೀಧರ್ ಜಿ ಅಲ್ಲ?
Yes sir.
ಹಾ.
Monday date
24th. 23rd of March. 23rd of February. Yes.
Okay, grateful sir.
Sir, list one serial number 30. The interim order extend ಆಗಬೇಕು. ಅದೊಂದು ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ಕೊಡಿ ಸರ್.
Yes sir. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಸರ್. ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಹಾ, ಡೇಟ್ ಕೊಡಿ.
ಲಿಸ್ಟ್ 1 serial number 30. ಲಿಸ್ಟ್ 1
ಹಾ, serial number 30.
ಲಿಸ್ಟ್ 1 serial number 30. ಇಂಟ್ರಿ ಮಾಡಿ 2 weeks ಅಂತ ಹೇಳಿ. 2 weeks ಅಂತ ಹೇಳಿ.
ಸರ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್, ಇಲ್ಲಂದ್ರೆ ಬರಲ್ಲ. ಮಾರ್ಚ್ 10th ಕೊಡಿ, ಆಗ್ತಾ ಇದೆ ಸರ್. ಸರ್
ಯಾವತ್ತು ಬೇಕು? ಅರ್ಜೆಂಟ್ ಇದೆ ತುಂಬಾ.
ಸರ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅದರಲ್ಲಿ.
ಸರ್ ಮಾರ್ಚ್ ಯಾವುದು ಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 30.
ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಲಿಸ್ಟ್ 1
30.
ಹಾ,
ಲಿಸ್ಟ್ 2 30.
ಲಿಸ್ಟ್ 1 30
ಅಲ್ಲ? ಲಿಸ್ಟ್ 1 30. Recommencing from 2nd of March.
ಸರ್ ಡೇಟ್ ಕೊಡಿ ಒಂದು ಸ್ಪೆಸಿಫಿಕ್.
2nd of March. Recommencing from 2nd of March. Yes.
ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಅಲ್ಲಿ ಕೂಡ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಅದರಲ್ಲಿ ಇಂಟರ್ ಮಾಡಲ್ ಇಲ್ಲ, ಬರೀ ಡೇಟ್ ಕೊಡಿ. ಹಾ,
ಸರಿ.
ಡೇಟ್ ಯಾವುದು ಸರ್? 32 ಅಲ್ಲಿ
24th.